I now declare open this public hearing of the Legal and Constitutional Affairs Legislation Committee inquiry into the provisions of the Migration Amendment Bill 2024. I acknowledge the traditional custodians of the land on which we meet and pay my respects to their elders past and present. I would also like to acknowledge and welcome other Aboriginal and Torres Strait Islander people who are participating in today's public hearing. The committee's proceedings today will follow the program as circulated. These are public proceedings being broadcast live in Parliament House and via the web. For the benefit of those participating remotely, I am the Chair of the Committee, Senator Tanita Green, and I'm joined today by the Deputy Chair, Senator Paul Scarr, Senator James Patterson, and Senator David Shoebridge is also joining us. Senator Alex Antic will be joining us remotely. I remind witnesses that in giving evidence to the committee, they are protected by parliamentary privilege. It's unlawful for anyone to threaten or disadvantage a witness on account of evidence given to a committee, and such action may be treated by the Senate as a contempt. It is also a contempt to give false or misleading evidence to the committee. The committee prefers evidence to be given in public, but under the Senate's resolutions, witnesses have the right to request to be heard in confidence. This is described as being in camera. If you are a witness today and intend to request to give evidence in camera, please bring this to the attention of the Secretary as soon as possible. If a witness objects to answering a question, the witness should state the ground upon which the objection is taken, and the committee will determine whether it will insist on an answer having regard to the ground which is claimed. If the committee determines to insist on an answer, a witness may request that the answer be given in camera. Such a request may, of course, be made at any other time. A witness speaking for the first time should state their full name and the capacity in which they appear, and witnesses should speak clearly and into the microphones to assist Hansard to record proceedings. Mobile phones and other electronic devices should be switched off or turned to silent mode. I now welcome representatives from the Law Council of Australia and the Human Rights Law Centre. Thank you for taking the time to speak with the committee today. Information on parliamentary privilege and the protection of witness and evidence has been provided to you and is available from the Secretariat. For the Hansard record, can you each please state your full name and the capacity in which you appear today? And we can start here in the room with the Law Council.
Yes, I'm Greg McIntyre, SC. I'm the President of the Law Council of Australia.
And I'm Karina Ford. I'm the Chair of the Migration Committee of the Law Council of Australia.
Thank you. And I understand some of your colleagues are joining us online.
Yes, they are. Yep.
Mr. Prince?
Yes, Dave Prince, appearing for the Principal Solicitor Consultants Lawyers for the Law Council of Australia.
Thank you. And Dr. Fletcher?
Yes, Adam Fletcher, Senior Policy Lawyer at the Law Council of Australia.
Thank you very much for joining us today. We also have the Human Rights Law Centre via video conference. If I can get you to introduce yourselves.
Good afternoon. I'm Josephine Langbian, Associate Legal Director at the Human Rights Law Centre.
Good afternoon. I'm Laura John, an Associate Director at the Human Rights Law Centre.
Hi, I'm Farhad Bandish.
Thank you very much. Now, before we go to questions, do you have a brief opening statement that you'd like to make? Mr. McIntyre, we can begin with you if you like.
Well, we've been asked by the Human Rights Law Centre that Mr. Bandesh go first because he has a limited availability on video.
Oh, no, I'm very happy to allow that to happen. So thank you. We'll go to you, Mr. Bandesh.
Thank you. My name is Farhad Bandish. I am a human being first. Then I am an artist, I'm a musician and a winemaker. Lastly, I'm a refugee. I am here today because I am one of the people who would be deported to a third country if this bill becomes law. Even though I have already lost years of my life on Manus Island, and I have spent nearly 5 years in Australia building a life with my partner. I'm a Kurdish refugee. I came to Australia in 2013 seeking safety and freedom. Instead, I was exiled to Manus Island, where I lost 6 years of my life in detention prison camp. I was on Manus Island during the violence that killed Reza Barati and injured hundreds, including myself. I could not believe the violence that I witnessed, that it's at Australian-run prison camp. I knew Reza called me uncle. He told me that he liked my smile. I think of him still and the life he could have had. I was eventually transferred to Australia for medical care. Without that, I could have lost my life. I didn't receive any medical care. Under this law, if I am sent to a third country, I am tortured in detention, I will not be brought to safety. This is what the government wants for people like me. But we will not give up. There are more than 1,000 people like me in Australia who suffer through the horrors of Manus and Nauru. Only 450 people will be resettled in New Zealand. The rest of us could be sent to a third countries under this bill. For the past 4 years, I have tried to rebuild my life from scratch. I have made a small house with my partner, Janelle, and our beautiful dog, Chia, named after a mountain in Kurdistan. I work with Bandish Wine and Spirits. I sing and I play music at gigs, sometimes the guitars, sometimes Kurdish traditional songs, mostly. I will try to forget what was taken from me over nearly a decade in detention prison camps. And I try to build a future for myself bit by bit. The Labour government watched what we went through on Manus Island and Nauru. It voted to bring us to Australia to provide with medical care. What has happened to this government now? This bill is horrified and will harm many people like me who call this country home and have built families, who have already been through so much. I have lost my family and home once, and others like me should not have to suffer through that again. Thank you.
Thank you, Farhad. If our colleagues at the Law Council would give us the indulgence of just saying a few brief comments to follow on from Mr. Bandesh's statement.
I think that's
this
fine.
bill.
Thank you. Yep.
Thank you. This bill, like the other legislative changes following NZYQ, seeks to impose further punishment on a small group of people who have already been doubly or in some cases triply punished. These people have been singled out for harsher treatment than the rest of the Australian community simply by virtue of their visa status. But although the bill purports to target bridging R visa holders, in fact, it will affect thousands of people. Any person who is subject to removal from Australia could be sent to an unspecified third country. That's any person, adult or child, refugee or tourist, without any consideration given to their connections to Australia or indeed their connections to the country to which they'll be removed. But it will be the people who cannot be returned to their countries of origin who are most at risk: refugees, stateless people, and people who have fled oppressive regimes. In 2001 and again in 2012, the Australian government thought that it could solve a political problem by leaning on our neighbours in the Pacific and spending millions of dollars to send refugees and people seeking asylum to remote places where they would be out of sight and out of mind. But what followed were years of well-documented human suffering. The consequences are still reverberating to this day. Australia's offshore detention regime has been condemned internationally at home, and warehousing people offshore didn't work then and it won't work now. But instead of dismantling this cruel and unnecessary regime, this bill seeks to expand it. It would allow the government to separate people from their families, sending them to permanent exile in third countries against their will, with no way to ever return to their lives in Australia. We don't know which countries will be included. We don't know how those countries will treat the people who are sent there. They could be detained arbitrarily, denied medical treatment, They could be violently attacked or killed, or they could be sent back to their countries of origin. This is not far-fetched, because all of these things have happened to people previously exiled offshore. But the Australian government must know that all these eventualities are real possibilities, because why else would the bill attempt to protect the Australian government from civil liability for the harm that people will inevitably face? There are many concerning aspects of this bill that we are happy to speak to, including the reimposition of constitutionally unsound bridging visa conditions, the power to strip refugee status from people living lawfully in the community, and serious breaches of the right to privacy. But we'll leave it there for now. Thank you.
Thanks very much for that opening statement. We'll come to questions to you shortly, but I'll invite the Law Counsel to make an opening statement. Thank you.
Chair, I haven't got leave, so yeah, I've got to go too.
You didn't get a pair?
No.
I didn't get a pair either. None of us got a pair.
Shorting your pairs.
Did you ask for one?
We did.
We'll have to adjourn because we don't have quorum. I apologise. We'll come back to you as soon as we can. Thank you. Resume the hearing. Thank you very much. After that brief adjournment, we'll go to the Law Council for your opening statement. Thank you.
Thank you. The Law Council thanks the Senate Legal and Constitutional Affairs Legislation Committee for the opportunity to comment on the Migration Amendment Bill 2024. At the outset, the Law Council wishes to express its most serious concern about the lack of opportunity to scrutinise this bill properly. The Law Council reiterates that concern in relation to the scrutiny timeframes given to a number of bills during this term of the Parliament. Having been requested yesterday to prepare a submission by this afternoon and to appear at this hearing means that proper consultation with the Law Council's constituent bodies and expert advisory committees has been impossible. For this reason, the Law Council's remarks should be considered preliminary and subject to amendment or clarification. The truncated process does not ensure proper democratic scrutiny of the bill by the Parliament and the community and undermines Australia's standing as a democratic global leader. The scrutiny process in relation to this bill is particularly objectionable given that it includes far-reaching changes to the law which will likely have a significant impact on the rights and liberties of many members of our community. It is imperative in assessing the necessity of a rushed legislative response to the YBFZ decision to continue to bear in mind that persons who have completed their prison sentence are routinely released into the community. Australia has strong police forces with calibrated investigative and enforcement powers to respond to any further offending. Detaining individuals preemptively to prevent them from committing future crimes must not become normalised in our otherwise free and liberal society. The bill seeks to amend the Migration Act 1958 of the Commonwealth to achieve a number of aims related to removals, including to facilitate the transfer of persons, including, it is important to note, not just those convicted of crimes, but also many vulnerable members of the community to third countries, and to pay those third countries for their part in this scheme. It would also grant extensive immunities to Commonwealth officials and anyone in those third countries in relation to anything done in connection with people's removal, including sharing their sensitive personal information with scant regard for it possibly being shared with those who might seek to do them harm. This raises serious rule of law and human rights concerns. This bill is a further example of a misguided approach to dealing with potential removals. We acknowledge that having an orderly, well-functioning migration program is a legitimate objective of government. However, we regard measures targeting a broad category of bridging visa holders, many of whom are vulnerable and have not committed any offences, and facilitating their removal to third countries that have not yet been designated and without any clear process of designation, rather than exploring less rights restrictive alternatives as an approach that is likely to be incompatible with Australia's international obligations and potentially inconsistent with the decision of the High Court in YBFZ. The High Court's findings in NZYQ and more recently YBFZ centre on the proposition that under the Commonwealth Constitution, punishment is properly the preserve of the judiciary and not the executive. Measures such as those in the present bill, which continually seek to test the bounds of the separation of powers doctrine, ought to be resisted on the basis that they may not sufficiently heed these important High Court judgments. These concerns are heightened given that there is such an abridged timeframe in which to assess the provisions for likely constitutional validity. In our submission, we also set out several related concerns with the bill, including that it could undermine domestic and international protections against refoulement. It would establish a removal mechanism without any meaningful administrative law-based safeguards, and it has potentially very significant financial implications, despite what is stated in the explanatory memorandum to the contrary. In the Law Council's view, a stronger focus on rehabilitation, including work rights to enable bridging visas holders to establish their lives and independence, would constitute a far better approach than a series of rushed legislative proposals raising further potential issues. Non-punitive alternatives to keep track of bridging visa holders, such as reporting requirements, should also be prioritised. Our principal recommendations are that the bill be withdrawn. If that recommendation is not accepted, to ensure that the bill receives proper scrutiny, the bill should be subjected to an inquiry period before the Senate Legal and Constitutional Legislation Committee of at least 6 weeks. That's our opening statement.
Thank you very much, Mr McIntyre. We'll go to questions now. I'll start with Senator Scarlett.
Thank you, Chair. Mr McIntyre, well, thank you to you and the team at the Law Council of Australia. I think you did an extraordinary job in terms of putting the submission in that you put in, and likewise the Human Rights Law Centre. I'm still getting my head around it. Can I ask you firstly in relation to breadth concerns, and in particular the definition of removal pathway non-citizen, and your recommendation 6, that the concern is that the current definition would extend the application of the bill to those who have ministerial intervention or court proceedings on foot, transitory persons, or persons who may previously have had a protection finding in relation to their cases and other categories. Could you just expand perhaps on that concern in terms of whether or not this bill is capturing, what additional cohorts is this bill capturing that weren't covered in the High Court cases?
Do you want me to answer
Yes,
that?
yeah.
It didn't specifically state all the cohorts, but in the explanatory memorandum it made it clear that it was to cover more than just the bridging visa R cohort, and it includes those who are unlawful, are potentially on a bridging visa E pathway to leave.
Right.
And in that, it includes the transitory people, because currently majority of them are either unlawful or are on bridging visa E's on departure grounds. So none have been allowed bar list for the purposes of going through the resolution of status pathway. And it could, as the Human Rights Legal Centre mentioned, it could actually include really anyone who holds a bridging visa E on departure grounds. It's that broad.
Okay, so the explanatory memorandum, this is paragraph 31 of your submission.
Yep.
The explanatory memorandum states that the definition of removal pathway non-citizen is not intended to cover other holders of the subclause 050 bridging general visa, which is also used for a variety of purposes other than as a final step before departure from Australia. Is it your concern that the drafting of the bill itself doesn't reflect that aspiration?
Yes, that's correct. And a similar form of this bill came up, it might have been earlier this year.
No, I remember.
You probably remember. And that was one of the things that was covered, was just the broadness of the definition, and including the ability for those who have been found to be owed protection to be expanded, to be revisited. What the bill doesn't do is it doesn't go through how that process would even be undertaken. And that could include those not only on the bridging visa R pathway, but potentially others.
Okay. Can I ask the Human Rights Law Centre, can you comment in terms of the breadth of the definition of removal pathway non-citizen, and from your perspective in terms of which cohorts or persons would be captured by this definition as it's currently drafted?
Thank you, Senator. If we could just clarify as a starting position, this term, removal pathway non-citizen, does not form the basis of this new power to send a person to third country reception arrangements. That definition is attached to the new powers to strip refugee status from a person who is living lawfully in the community. But the people who could be subject to these third country arrangements include absolutely any person who are subject to the duty in Section 198 of the Migration Act to be removed from Australia. So this could include a person who is in detention and doesn't have a current migration process on foot, or even some who do. So, for example, people who still have outstanding requests for ministerial intervention. which could be because the circumstances in their country of origin have changed and they need to lodge a new protection visa. It could include a person who has an entitlement to lodge a protection visa but hasn't been able to do so yet. It could include people who are in detention simply because their visa has expired. This is an incredibly broad power that is not limited to removal pathway non-citizens. It applies to any person who could be removed from Australia.
Okay. I'll move on to constitutional concerns that the Law Council of Australia has spoken to in your submission. And I note that in particular in paragraph 37, you make the comment that I'll quote for the Hansard record, given that the plurality opinion in YBFZ already establishes that the character of a power to impose curfews or restrictive ankle monitoring devices is prima facie punitive, in the constitutional context, the critical question is whether there is justification for this non-juridical exercise of power interfering with liberty or bodily integrity. As I read the bill, it's based on the principle that the reason for the power is in effect to protect the community from potential serious offending, and there's a link back to a range of serious offences which I think define what serious offending or serious harm to the community may be. Why does the Law Council let me put it this way, doesn't that in a way address the constitutional issue that it's not so much punitive, it's actually preemptively trying to protect the community where the Minister has, on the reasonable balance of probabilities, formed a view that the various restrictions, either one of them or a number of them, are required to protect the community from that serious offending?
It depends on how the Minister goes about making that decision. We don't know how the Minister is going to arrive at that decision, but what the legislation allows the Minister to do is to preemptively arrive at that conclusion and impose the conditions, and then after that the bill would then allow a process of objection by the person affected by that. We don't know how long that process will take. We think that there's a significant risk that a collection of people will find themselves subject to those punitive conditions for however long it takes for any review of that process, if they choose, once they've chosen to exercise the ex post facto rights they have to seek review of that decision. Knowing how these things have operated in practice, that could be several months, it could be years. The person will be subject to these punitive conditions on the basis of the Minister having arrived at having announced that the Minister has arrived at that level of satisfaction and immediately imposed the condition. We note also that can happen orally, without anything in writing, without any prior notice, and without anybody other than whoever is advising the Minister knowing on what basis the Minister is making that decision.
Is it correct though, Mr McIntyre, and tell me if I'm wrong, so I'm still trying to get my head around it. As I read it though, the person who's subject to the potential exercise of that ministerial power must have first been found guilty of an offence which is a serious offence sometime in their past, and then there's a list of potential serious offences. I think the general benchmark is an offence with a maximum period of imprisonment of at least 5 years. So it seems to be saying, well, you've got to get through that gate first. You must have committed an offence of that order before the power of the Minister is enlivened. Is that correct?
Yeah, that is correct. So the regulation defines what serious offence is, and you're correct, it is at least 5 years imprisonment or life, and then it lists the type of offending that would fall under that. The issue, though, is that when you then go to the test, there is no ability to, say, give a fair go to the person who may be subject to it. So whatever is before the minister will be what the minister may take into account. There's no ability to, for example, offer procedural fairness or a right to be heard prior to it. And the other concern is in relation to it then being applied, you can apply to have it revoked. The issue is when will a minister revoke the decision of having already determined that it was reasonably necessary and reasonably appropriate and adapted? It's just hard to see that a minister will ever overturn it, and that then leads to the issue of, is it really the same sort of test that was put in place in the High Court decision, in that we will never see decisions overturned? So the challenges will come through both sections here. They will come not only through the original imposition of the conditions, but it will also come through the revocation process. And that's where our position is that it really should be the court determining this, not a minister.
Okay, I understand.
Yeah.
I understand. I want to ask a question to the Human Rights Law Centre because I'm sensing the call might be shared soon. And that is, how does the bill deal with the situation of a family? So, as I've read the bill, there's a distinction between how the bill operates with respect to a child as opposed to an adult. So, from your perspective, how does the bill respond to a situation of, say, a mother who has a child?
Thank you for the question, Senator. One of our key concerns with this bill is that it doesn't seem to recognise the value we should put on family unity. And it certainly doesn't attempt to grapple with the very complex situations that may occur where people in the one family unit may have different visa statuses. So something that's of grave concern to us is that this bill actually contemplates that children could be sent to a third country. It also contemplates that a child who is an Australian citizen could have their parent sent to a third country, because there's nothing in this bill that provides any protections for children. The committee will shortly receive a submission from the Women's Legal Services Australia that steps out some of the specific risks for women who have experienced family violence, because that's another situation that this bill just doesn't contemplate at all. And if I could also just go back a moment, Senator, to the question of constitutional validity, because I think it's a really critical issue for the committee to grapple with. Our view is that the bill is constitutionally unsound. And that's not at all surprising, given that the bill was introduced a mere 24 hours after the High Court handed down its decision in YBFZ. And yet the government would have us believe that these amendments have been carefully constructed to avoid another round of invalidity. The key problem is that the reformulated test in the bill doesn't change the underlying nature of the curfews and the ankle bracelets. These are still conditions that limit freedom and bodily integrity. And so the government would have us believe that the imposition of these conditions is about the purpose of protecting the community. But let's not forget that the government made that argument in YBFC and the majority of the High Court just didn't buy it. So some tinkering with the legal test, which is what has happened in the bill, doesn't change the fact that these conditions are imposed to punish a small group of people. In fact, that's why they only apply to a small group of people on the basis of their visa status, and they don't apply to, for example, every Australian who has some point in their lives committed those same offences. And I also just want to clarify, it's not necessary for a person to have committed serious offences in the past for these conditions to be imposed. What the test requires is for the minister to somehow divine a person's risk of committing a serious offence in the future. How the minister intends to do that is completely opaque to us. So really what the government should be doing is rather than focusing on passing more laws that are constitutionally unsound and that will almost inevitably be challenged. They should be focusing on the fact that this small group of people cannot be punished yet again. The High Court told us this a year ago in NZYQ, and they told us again last week in YBFC.
Okay, just playing devil's advocate with one follow-up question, if I can, Chair. But doesn't the fact that the minister has to actually direct their mind as to whether or not on the balance of probabilities there's a reasonable chance, or I can't remember the particular phrase in the bill, of potential offending. So as opposed to these conditions being applied automatically, the minister has to actually consider on the balance of probabilities that there's a necessity to impose either one of these conditions or a number of these conditions in order to protect the community. That does make this bill somewhat different from the bill and the regs that were considered by the High Court in the most recent decision. Isn't that correct?
We would call that some legal tinkering around the edges, because the point you've made is actually quite important. What has remained in this version of the legislation is that it's still the minister who makes the decision to impose the conditions. So the test the minister has applied has changed around the edges, but it's fundamentally still the minister who's making that decision. And what the High Court has told us in NZYQ and again last week in YBFZ is that the fundamental principle that arises from our separation of powers under the Constitution is that the executive government, the minister, cannot punish people. So the fact that the minister is still the one making these decisions means that these laws are still constitutionally unsound.
Okay. Thank you, Chair.
Thanks, Senator Scarr. Senator Shoebridge, you have the call.
Thanks, Chair, and thanks all for coming so quickly. And I share your concerns, I'll be quite frank, about the way in which this process is happening without proper scrutiny. I might just first of all address some questions to you, Fahad. You've been in Australia for some time now, and when you see legislation like this presented, which seems to be targeting you, how does that make you feel?
I don't know how to put it in words because it's really hard. I'm still suffering. I'm still panicking from any news, bad news from the government. So I'm sure so many people are like me. They don't know what to do. So I don't want to lose my family. I don't want to lose my dog. I don't want to lose this country. I think that's enough. I cannot bear it. This is too much. This is too much.
And Fahad, I know it's hard to talk about, but you've experienced being removed to a third country without protections, and you spoke about losing your friend in the violence there. Can you tell this committee what it's like to be removed to a country without protections?
It's like 2013. They want to exile me to their country. So there are so many nightmares is coming, so tortures in different ways. For medical treatment, I am sure is one of those. We will suffer a lot. I am one of those suffer for many reasons. The doctors judge me, the immigration judge me, the officer judge me. I am stateless. I am stateless. And I built, I think, this country, my life in this country. So even I cannot think about it. Once again, this government wants to exile me to another country. So I'm 40, almost 4. 8 of my years was in war between Iran and Iraq, and almost 10 years in detention. This is almost 16, 18 years old gone. So when do you think, as a human being, I have right to think about my future? I'm a human. I have right.
Fahad, I have heard your music. I've listened to your music and it's quite beautiful. I haven't tasted your wine, and I would like to at some point. but being able to have your home here, and after what happened to you in Iraq, in the war, what's happened to you in Manus Island, being able to have your home here, what does it mean?
I think people here, they're beautiful, they're amazing. I feel really comfortable with people. I feel I am part of this society. Of course I am. I share my music, I share my language. I also write song in English. They love it. So I think life in here is safe for me, and this is what I'm looking for. And that's why I decided to make wine as well. So I am a guitar maker as well. I built a lot of classical guitar, and now I'm making electric guitar. So do you think I am harming people in here, or I'm contribute to this country? I'm a bad person, do you think, or I'm a good person? So why the government doesn't want to welcome someone like me? I'm skilled in so many different ways.
Thanks, Fahad. Could I perhaps go to the Law Council or Human Rights, HRLC, in whichever order you wish, maybe starting with those in the room. There doesn't seem to be any protections in this bill against refoulement. Remarkably doesn't seem to be any protections. Am I misreading the bill?
No, there are no protections for that. I mean, because there's no detail as to what agreement would be in place with a third country in terms of also what may happen if a third country chose to, there's no requirement for that third country to be signed up to the conventions, for example.
So they don't even have to be a party to the Refugee Convention?
No, and it's probably very unlikely they would be. If you look at past history of deals that have been made, not just here but in the UK, I think the best example in the UK is the failed Rwandan removal country. You know, sometimes it's easier to deal with countries that, because this is the other thing that's missing from this bill, is just the sheer cost of what it's going to incur to Australia to even get into such an arrangement. I don't know, David, do you have anything to add on that?
No, I agree. It's the omission is stark.
It also does.
There's nothing that there's no way third country returning or reforming that individual to their country of persecution.
Ms. John or Ms. Langmuir, do you?
We absolutely agree. That's absolutely right. People could be sent to third countries that are not signatories to the Refugees Convention, countries that have no obligation to uphold any human rights standards or any standards really whatsoever towards the people who are sent there. There's nothing to stop those third countries from sending people back to their countries of origin, from detaining them indefinitely, or from subjecting them to any other kind of mistreatment. There's absolutely no constraints on that whatsoever. The other area where the risk of refoulement arises is in the provisions that purport to expand the minister's power to strip refugees of their refugee status, which is going to expose a whole new group of people to this risk of being returned to persecution.
And it's probably worth noting that while the debarment officers in Australia are required to act in good faith and they're protected against civil suit as a consequence, no such requirement for act in good faith extends to offshore individuals in any way.
Yeah, we might come to the fact that there's vastly more protections for government officials causing people harm or potentially causing people harm than anyone subject to the power, simply how this bill is drafted. But there also seems to be no limits on who the minister can or the government can enter into a third country deal with. So, I mean, names that the government has entered into or deals with countries such as Nauru or PNG, potentially Cambodia, but it could be China or Iran or Russia. There's literally no restraints at all. Whoever they cut a deal with, is that how it's drafted?
Yes, correct.
Exactly.
Have you ever seen any legislation that proposes to give a minister and a government such powers. They literally cut a deal with any country on the planet, regardless of their human rights record, regardless of their legal protections, and then just send people there?
I assume there may have been similar legislation when Nauru and Manus Island were created, and what is interesting is we don't seem to learn from the consequences and the damage of what has occurred as a result. So it's nearly like history repeating itself again to another cohort of people that we will incur lifelong damage to.
Yeah. And as the Human Rights Law Centre says, there's actually not even a requirement that the government check or the minister check that the country they're sending them to won't put people straight into jail. Like literally...
That's right. Sorry, I interrupted
or
you,
subject them
Senator.
to capital punishment.
Or send... And if someone... An example that was raised with me by a stakeholder was somebody may have come to Australia from seeking asylum because of they identify as part of the LGBTIQ community. That may be unlawful in the country from which that they've come, and that's why they're seeking asylum. And they could then be deported to a third country where it may also be unlawful. And in fact, then this bill allows their criminal record to be shared with that country where they could be put in jail.
Correct, and it doesn't have any protection of how that data would be protected in that third country. So if by chance that data was released, that person could actually face harm from both the country itself, but also persons within that community. So the release of the information is also a concern in the way that it's undertaken.
The example of Manus Island shows what happens when this runs its term. There are currently some 42 people who have been effectively abandoned by both Australia and the Papua New Guinea government who were detained in Manus Island, now with no support, no protections. Is there anything in this legislation that would protect people once the agreement with the third party had expired, or do they face the same abandonment issue as happened in Manus?
We have no idea what will be in these agreements for a start, so the answer is no.
And there's no minimum protections in the agreements, no requirement for a basic payment of sustenance or...
Well, it's just not included in the bill, so there is no... The answer, as Greg pointed out, is no on that question also.
Yeah, I might just go to the Human Rights Law Centre. Is that right? There's literally no requirement even to make a basic sustenance payment in the third-party agreement section?
That's right, Senator. The way the bill is drafted, the government purports to completely wash its hands of responsibility for what happens to people after they are exiled to a third country. There's no requirement that those people be provided with any ongoing support, while the government has the ability to make monetary payments for any functions to do with those third country reception arrangements that it likes. For example, that could be funding the operation of a detention centre. There are no obligations on the government to do so, so we absolutely could see a situation identical to that which we're seeing in Papua New Guinea at the moment, where the government purports to abandon people that it has put in these abhorrent situations and refuse to take responsibility for their futures and their livelihoods.
And in fact, they seem to have thought this out in advance because they've actually put in this legislation some of the most comprehensive immunities for the government. So there's not even a good faith requirement for the exercise of these powers. They're given immunity even if they're acting in actual bad faith, knowing people will be harmed. Is that how these immunity provisions work?
It does seem to do that, and it also applies to the third-party countries, agents of the third-party countries that they might enter into these agreements with.
Could you just explain that a little more, Mr McIntyre?
Let's see that provision.
While he's in there.
No. Is it? So there's no liability in the Commonwealth for anything Commonwealth does, but also for anything that a foreign country does.
That's right. I'm just seeing. We deal with it at paragraphs 64 through to 69.
While you're looking at that, Mr. McIntyre, I might go back to the Human Rights Law Centre. So a government official with these immunities could see that a person might be particularly vulnerable and at risk for removal to a third country, have credible evidence that they may be subject to some brutality or even refoulement where their life is in danger, could have all that evidence in front of them and then still exercise the power to have them removed to the third country, knowing the harm will happen. And they would be immune from suit. They would be protected from any damage, even if it came to pass. Is that how this works?
Senator, these provisions purporting to protect the Australian government from civil liability are incredibly broad, as you have pointed out, and we just want to emphasise how important, how critical the government's liability for the harm that they've caused to people offshore has been in the past. It was only through recourse to Australian courts that people in Nauru and Manus Island who had been subjected to incredible medical neglect were able to finally compel the Australian government to deliver on its duty of care and bring them to Australia to access life-saving medical treatment. These provisions, if they are in place, will prevent a person who is removed to a third country from having access to the courts to seek their transfer.
Is that the Law Council's reading of it as well?
Yes, that's correct. So, I mean, you know, the explanatory memorandum indicates that there may be some ways that you can access the courts, but not in terms of adequate compensation. And the reality is often the removal process in these cases. I mean, this is, again, learnt from past experience, I mean, because there are a number of people who have received compensation due to the harm that has been caused both through the offshore detention process, but also even through the removal process. Sometimes the removal process goes wrong. And so to actually exclude the ability to be properly compensated is a real concern. And of course, there is really no jurisdiction Australia has in foreign countries where things go wrong also.
That's the answer to the question I wasn't immediately able to answer, and we haven't dealt with in our submissions, because clearly Australia has no control over sovereign citizens of other countries. So if Australia enters into an agreement with some agent of some country and that person does something which we would regard as inappropriate, there's just no way that Australia has any legal jurisdiction to deal with that person.
But if this becomes law, Australia enters into an arrangement with a third country which may, for example, have no medical support in it, or the most rudimentary medical support. The government could literally remove someone from the country here who was on kidney dialysis, life-saving kidney dialysis, deport them to a third country where they know there would be no medical treatment and no dialysis, and watch them die, and there would be no legal recourse. That's actually what could happen, isn't it?
The bill would allow that.
There's only one limitation is in the proposed subsection 12 of the new section on this issue. It protects Australian officers when they exercise these powers in good faith. But then the same, right under the sub-provision, does not have any good faith caveat for the conduct of any other foreign country or foreign agent. It is stark that there's no good faith requirement for anyone offshore. That's the only limitation that we have in this bill.
Yep.
Sorry, Senator, could we just mention also that in the example that you gave, if somebody requires dialysis, that's not a matter that would prevent their removal, even if an officer of the department were acting in good faith in accordance with their duties. So the answer to your question is yes, someone in that situation absolutely could be removed offshore.
And it's just not a relevant consideration? Just irrelevant? The fact they may die if they get put there, just irrelevant?
Correct.
Do you have any idea of the numbers of people who are potentially subject to these powers? We'll no doubt ask questions of the department later. You gave an indication of some of the classes. Ms Ford, any idea of the kind of numbers?
Well, the Nauru Manus cohort is significant. I think it'd still be probably at least 1,000 or so people in that cohort. And then the other cohort is the Bridging Visa R cohort, and then Bridging Visa E visa holders who are on departure grounds. It could be tens of thousands, potentially much greater, and I think that is a question that you should put to the department, because there are many in that cohort.
Well, we'll hopefully get some of those answers. But this includes, this may include a mum and dad who may have 3 kids here who are Australian citizens. That there's no regard to whether or not, if mum and dad are deported, the 3 kids will have no parents.
Yeah, there's no protection in the bill to children over the age of 18 or splitting families. So effectively you could split a family and they don't have to have regard to that, which is why it's such a concern for the Manus Nauru cohort, because we have children now at the age of 17 doing their Year 12 currently, who will fall within this bill very shortly. But effectively, yes, you could have a situation where mum or dad goes and the children remain here.
And if we could also just add on that point, Senator, just in relation to children, in the explanatory memorandum, the department suggests that existing safeguards will be used as a matter of practice, policy and procedure to ensure the best interests of children can be considered ahead of a person's removal from Australia. So by that, we take it to mean that the department will rely on unlegislated, unenforceable administrative arrangements as the only barrier to a child being ripped apart from their family, with their parent being sent to a third country, or indeed the child themselves being sent to a third party. Needless to say, that's a wholly insufficient safeguard for a scheme that contemplates permanent exile.
Thanks. There obviously are many more questions, but we just, as you probably know, we have very limited time today. Thanks all so much, and particularly given you had almost no notice of this. I really appreciate all of your assistance.
Thanks. Thank you very much. That's all the time and questions we have for you today. I don't think you did take any questions on notice, so we don't need to go through that process, but we thank you for your time and your submission.
Thank you.
Can you pass me your opening statement? Thanks. Thank you. I now welcome via video conference representatives from the Refugee Council of Australia, the Asylum Seeker Resource Centre, Refugee Advice Casework Service and the Caldwell Centre for International Refugee Law. Thank you for taking the time to speak with the committee today. Information on parliamentary privilege and the protection of witnesses and evidence has been provided to you and is available from the Secretariat. For the Hansard record, can you please state your full name and the capacity in which you appear today? And obviously everyone's joining us online, so I might just call out the different organisations and we'll start from there as we have done in previous hearings. So thank you. If we can start with the Refugee Council of Australia.
Thank you to the committee for the opportunity to make a submission and to speak this evening.
You just want to state your name and your
I'm sorry,
capacity?
that was, of course. My name is Rebecca Eckard, and I am the Director of Policy and Research at the Refugee Council of Australia.
Great, thank you.
The Refugee Council...
Just hold on one second. We're going to go through all of the witnesses and then we'll come to you. So thanks. The Asylum Seeker Resource Centre, if you just state your name and for the Hansard record.
It's Jana Favero, Deputy CEO at the Asylum Seeker Resource Centre.
And Rachel Saravanamuthu, Legal Policy Lead.
Thank you. And the Refugee Advice and Casework Service?
Sarah Dale, Centre Director.
Ahmed Sawan, Supervising Senior Solicitor.
Great, thank you. And you're also joined by another colleague, I believe.
We're joined by Community Advocate Bruce Bachani.
Hello, everyone. Can you hear me?
Yes, we can. If we can just get your name for the Hansard record, and then we'll...
My name is Beruz Buchani.
Thank you very much for joining us today. The Cowdell Centre of International Refugee Law, if I can just get your name for the Hansard.
Anna Talbot, Strategic Litigation Network Coordinator for the Cowdell Centre.
Wonderful, thank you very much. Now I'm going to invite each organisation to make an opening statement. I'm not sure whether there's been a discussion about what order, but otherwise I can stick with the order in my program. Yep. I'm seeing nods.
We were hoping, that we were hoping to stay in the order, but to switch the Cowdell Centre and Rex, so that Rex could provide their opening statement last.
Okay, fantastic. I can facilitate that. So, Ms. Eckhart, over to you.
Thank you so much. As a reminder, the Refugee Council is the national peak body for people from refugee, asylum-seeking and humanitarian backgrounds, and the organisations and individuals who support them. The Refugee Council strongly opposes this legislation. It has been rushed through with little time given to understand the dire impact on Australian families and communities. It would see people forced to unknown or at least undisclosed third countries where they could face imminent harm. The bill would expand the brutal regime of offshore detention via third country reception arrangements, where Australia would pay significant taxpayer money to warehouse people, and such financial arrangements with third countries carry substantial risks, as evidenced by the investigation the Australian government launched last year into suspect payments made to politicians and officials on Nauru and PNG as part of their offshore processing arrangements. There are no safeguards in this legislation to ensure that people are protected in these third countries or even protected from refoulement, that is, being sent back to persecution and irreparable harm. Unfortunately, Australia has recently participated in chain refoulement when it sent several people from a nation in Central Africa who had arrived on the Australian mainland back to PNG, the last country they had passed through, and PNG authorities then sent them back to the very country they fled from without adequately assessing their identity or protection needs. This legislation would create the circumstance where this could happen to even more refugees. And since the bill relinquishes any liability or responsibility from the Australian government regarding people removed from Australia and their subsequent treatment in a third country, there is no accountability. The legislation goes beyond what the government has described about it only applying to people with a criminal history. The legislation clearly sets out how it could apply to thousands of others, including recognized refugees and people seeking protection, subjecting them to further harm. Forcing people to these third countries would also permanently separate Australian families from one another, including parents, children, partners, and siblings. In the Refugee Council's submission, we highlighted alternatives to this bill, including building upon the rehabilitation and reintegration services for people transitioning from immigration detention and tailored support for people to help engage them in their immigration process with dignity and self-agency. Thank you for the opportunity.
Thank you very much. The Asylum Seeker Resource Centre.
Thank you. I'll provide the opening statement alongside my colleague Rachel for the Asylum Seeker Resource Centre and acknowledging that we're joining from Wurundjeri land. Our submission and evidence at the inquiry is based on over 20 years working directly with people seeking asylum and refugees. Not only does the ASRC legally represent people navigating the complex refugee determination process, but we're also people's supermarket, pharmacy, local doctor and employment service. Over 2 decades, we've seen the devastating impact laws and policies have on the lives and families of people seeking asylum, refugees, men, women and children. This bill is yet another attack on migrants, refugees and people seeking asylum without adequate safeguards. It introduces unprecedented powers to deport people to unspecified third countries, preemptively absolves our government from any liability for the harms caused to people sent to third countries, gives power to overturn people's protection findings and breaches people's privacy. The bill is the biggest and most cruel change to the way we treat refugees and people seeking asylum that we've seen since offshore processing was introduced. And let's make no mistake, this bill does go much further than just working to circumvent the recent High Court decision. People impacted includes those failed by the fast-track process and those transferred to Australia after spending years in detention on Manus and Nauru. Rather than offer people the safety they deserve, this bill would further punish them. The bill leaves people to possibly be detained, sent offshore to undetermined third countries who we have paid, and with no guarantee they won't be returned to harm. While we appreciate the opportunity to appear at the committee hearing, we are very concerned about the rushed nature of this legislation. With so many different issues being debated in the final 2 weeks of the sitting period, there's been no opportunity to properly scrutinise this legislation and work through all the possible unintended consequences. The government's trend of hurriedly passing legislation without adequate scrutiny or consultation, which significantly impacts the rights of refugees, people seeking asylum and their families, is deeply troubling. This type of government decision-making jeopardises our democracy and transparent governance. Even the government-led Parliamentary Human Rights Committee yesterday raised grave concerns that limits multiple human rights, stating it remains unclear why punitive conditions, including electronic monitoring, are necessary to manage the potential safety risk posed by those released. This bill could impact tens of thousands of people. We all know people, neighbours, co-workers, friends, teachers, nurses, your local baristas, who aren't born in Australia but are without a doubt part of our community. These are people who call Australia home. People such as our client like Hamza, who fled Iran due to his sexuality and applied for a protection visa in Australia. As he arrived by sea, he was subject to the flawed fast-track process and his sexuality protection claims were not accepted by the then Immigration Assessment Authority. Hamza couldn't afford a lawyer like many, so was unable to seek judicial review of his IAA decision. He has sought ministerial intervention and has new evidence to provide in support of his sexuality claims, namely that he's been in a homosexual relationship with an Australian citizen man for 4 years. However, Hamza has been granted a BVE on departure grounds, which expires in a month. If the bill is passed and Hamza's BVE is not renewed, he'll be exposed to detention and deportation to a third country who's entered into one of the reception arrangements, including somewhere like Nauru. This could be a country where it's unlawful and unsafe for people identify as LGBTIQ and where Hamza could face serious harm, including refoulement to Iran. We should all be equal before the law, regardless of where we've been born. And as a community, we must be very careful that people's lives and freedoms are not traded for political convenience. That is what is happening here. Therefore, we oppose this bill in its entirety.
Thank you very much. The Caldor Centre for International Refugee Law.
Many thanks for taking the time to hear from us this evening. I would also like to acknowledge that I'm giving evidence from the sovereign unceded land of the Bidjigal people. The Caldor Centre is the world's leading research centre dedicated to the study of international refugee law. I would like to start by expressing concern regarding the rushed nature of this process. This is the fourth bill that has been introduced since NZYQ in the last 12 months. That case brought us into line with all other comparable countries around the world. No other liberal democracy allows for, let alone requires, indefinite mandatory immigration detention. Since then, there have been two major High Court cases challenging the government's responses to that case. The Commonwealth won one and lost one, but even the case that it won, there was a carve-out for the position of the intervener. There is a real need for the government to take time to develop a comprehensive immigration policy that complies with the Constitution and our obligations under international human rights law and international refugee law, in consultation with affected communities, legal experts and the sector, instead of repeatedly adopting a rushed response to these highly complex issues. In terms of the content of the bill, the Caldor Centre's concerns focus on two main points. Firstly, the introduction of third country reception arrangements, which could lead to so-called chain refoulement, as we've already heard, and put Australia in breach of its international obligations. Australia's non-refoulement obligations require it to both refrain from sending someone back directly to a risk of harm, as well as from sending them to a third country that may itself send them to a risk of harm. This is sometimes referred to as chain refoulement. The second focus of our comments today is on the proposed civil liability immunity provisions. We're also deeply troubled by expanding powers to revisit protection findings and reintroduction of intrusive monitoring conditions for people released from immigration detention, and we will be addressing those issues in our forthcoming submission. All of these provisions are likely to lead to lengthy, complex litigation, creating even more legal uncertainty. The bill would allow the government to send people who do not have a visa but cannot be removed to unspecified third countries. Unlike the existing regional processing provisions, there is no legislative protection from refoulement for people removed to a third country in this way, meaning chain refoulement is a real risk and there is no clarity in the bill or accompanying documents that durable solutions would be found. The bill explicitly envisages that people removed to third countries could be detained. It also anticipates sharing criminal histories with third countries without any safeguards to prevent those histories being shared in a way that could harm the affected person. There is no requirement that such people pose a risk to the Australian community before they could be subjected to removal. Similarly, there is no requirement that risk assessments be conducted to assess the potential impact of removal on that individual, despite Australia being aware that some third country processing or resettlement can be particularly harmful for certain cohorts, including those with pre-existing mental illness, women and sexual minorities. Some people liable to removal under this bill have been in Australia for many years and have built lives here. These removals could have devastating impacts on their families and communities left behind in Australia, including children. The bill also contains proposed civil liability immunity for actions taken by the Commonwealth or Commonwealth officers to effect removals to third countries, or things that are done in those third countries. Civil liability claims have been the primary safeguard for people removed from Australia for regional processing in the past. Immunity from such claims would mean Australia could operate with near impunity, so long as its officials operate in good faith, which is undefined. Severe harm could be done as a result. For these reasons, we propose that the bill be rejected in its entirety.
Okay, thank you very much. We'll now go to the Refugee Advice and Casework Service. Thank you.
Thank you, Senators. Good evening. I would like to begin with an acknowledgement of the traditional owners of the lands in which we're calling from. We're on the lands of the Gadigal and Bidjigal people of the Eora Nation, and we pay our respects to elders past and present. I thank the committee for the opportunity to provide evidence with respect to the Migration Amendment Bill, as it will fundamentally impact the people assisted by RACS. RACS acts for and assists refugees, people seeking asylum, people that are stateless or displaced, who are in the community, in immigration detention centres, alternative places of detention and community detention. We assist people who have criminal histories, as well as the exceedingly large majority who do not, to access safety, security and permanency in Australia. We recognise that a person's criminal history is often informed by significant trauma, mental illness, poverty, and a fundamental lacking of belonging, as well as an access to services. It is important to understand that the cohorts of people we make reference to today, irrespective of their arrival in Australia or behaviours that may have followed, have families, children, parents, and otherwise community in Australia who are also gravely impacted by brash legislation such as this. RACS follows evidence provided by the Law Council, Human Rights Law Centre, and appear here with colleagues whom we know we align with in terms of the legal principles and objections to this bill. We particularly rely on our colleagues at the Cowdell Centre for their expertise in the application of precedents, law and policy in this matter. The High Court found in YBF said that a use of certain visa conditions was punitive, so punitive as to be unconstitutional. In response to this, the government has put forward legislation enabling them to remove people to a third country, well beyond the cohort of individuals that the series of High Court cases the past 12 months has considered, and to do so with broad sweeping powers, including the stripping away of a person's refugee status. And to what? My colleagues have referred to this as offshore warehousing, which I believe is a generous framing at best, as it indicates a semblance of process or plan. Individuals are to be removed to countries for how long, where, with what status, to potentially face return to a place that Australia found they may be subject to torture, cruelty and death, or in fact face permanent family separation. None of this has been explored or considered in any level of detail, And worse, the government seeks to absolve itself of all civil liabilities in this process. The government has misled the Australian people as to say such measures are a necessity to ensure the safety of the Australian community. Yet this proposed process holds no such assessment of said risk and includes thousands of people for whom this kind of risk was never a question. Many of the people impacted by this will be those who have been simply failed by Australia's immigration systems, flaws which this government have accepted and remedied to some extent. But what they have failed to do is remedy this for those that were affected by such failures. Instead, this community are yet again met with more cruelty and to be treated as less than. RAC submits this bill ought to be rejected in its entirety. The rushed nature of law, lacking any ability for tangible scrutiny about something this fundamental to a person's right to liberty, safety and family unity cannot be supported. I'd now like to hand over to our colleague Baruz Buchani for his reflections.
Thank you. Should I start?
Yes, thank you very much.
Yeah, thank you very much for having me. Thank you for everyone. Actually, I'm not going to use the language that our colleagues from the organization use because I'm not a law expert, but I just would like to talk on based of my experience. And I don't know that what I said will actually impact on the senators to make decision or not, because that is our experience. We've been writing about this cruel system for many years, and everyone in Australia heard about it, about how these policies in Australia create a tragedy. But after many years, again, we see that the Australian government is going to introduce this bill, which is very inhuman. On base of my experience as a refugee, as a person who experienced the Australian detention system in Manus Island and in Australia, and on base of my experience after starting a new life in New Zealand as a refugee and meeting with refugees in Australia. I visited Australia 2 times. I met with many refugees. I heard many stories, and my evidence, what I say is on exactly based off my life experience. I think this policy, what is really important, that people in this room or in the Senate or in Australian Parliament should consider and think about it, is that you are making this policy and that impact on people's lives. For refugees, it's almost impossible to start again in a different place, which we see that in this bill is going to banish refugees to a third country. Refugees already left everything. Refugees already lost everything. And on base of my experience and meeting with refugees in Australia, they have been a part of Australian society. They've been contributing to the society. They've been in Australia for more than a decade, some of them 15 years, some of them 14 years. They already established a life in Australia. They already are a part of a community. And now, on base of this law, this bill, you are going to send them to another country to start again. And we know those countries that you are going to send people, actually, they can detain them, they can deport them, they can torture them. That is really important, that as a refugee, people already established a life in Australia. in a very difficult circumstances, because we know how Australian immigration system has been targeting these people for many years by sending them letters, by put them in detention, by giving them just a temporary visa for many years, but they've been able to establish a life in Australia and make friends, make partner, have children, have a job, have Australian friends, make a community. This is on base of my experience, because I know I met refugees who went to Australia under Medivac law, and then later they came to New Zealand, which is a good country, but I know that how people struggle with PTSD, and how it's difficult to start a new life, even in a country like New Zealand, that we know that has a better record to compared to most of countries on the earth. So my message is very simple. This policy, you are making a policy that damage people, hurt people who already are a part of the community. And what are you going to achieve? That is a question. What are you going to achieve by this policy? Nothing. You just make a tragedy worse, and Australia will lose its reputation internationally even more and more. So my message is very simple. So hopefully that you listen to it or consider it or think about it, at least imagine. I know that most of the senators in Australia, probably many of them have not met even a refugee or one of these people in their lives. You haven't met them, but they are people. Try to imagine who they are. They are just human beings. Thank you.
Thank you very much. And we're going to go to questions, and we'll try to direct those as best we can to the different organisations. So just bear with us. Senator Scarr, did you have any questions?
Yes, thanks, Chair. I'd like to ask a question first, and perhaps to the Cowdor Centre for International Refugee Law first, in relation to your views with respect to the constitutionality of the bill and the regulations. As I read it, in relation to the imposition of things like electronic monitoring, curfews, and those type of conditions, the change has been that the minister has to actually make a positive decision, albeit on the balance of probabilities, that the application of a condition or a combination of conditions is reasonably necessary to protect the community. So that's a change in terms of the scheme from the most recent decision, where the restrictive provisions applied unless the minister decided they didn't apply. From your perspective, what's your view, given that change, in relation to the constitutionality of the bill?
Thank you for your question. I'll start by saying that I'm not a constitutional lawyer, and the Cowdor Centre is not a centre of constitutional law. So we can't speak specifically to constitutional issues. But what I would say is there has been a fairly consistent message from the High Court in the judgments that we've received in the last 12 months since NZYQ, that it will be paying very close attention to ensuring that the separation of powers between the legislature, the executive and the judiciary is respected. And it's not clear to me at all that these changes would meet the threshold that the High Court has set down. Ultimately, it's going to be a question for the High Court.
Do any other witnesses have any views they'd like to share with the committee in relation to that issue of constitutionality? Refugee Council of Australia first.
I would defer to my legal colleagues so as to not enter into that space. Thank you.
Okay. Asylum Seeker Resource Centre.
Briefly echo what our colleague at the Counsel Centre has shared, that there are still concerns, especially given the rushed nature of this legislation, whether these amendments that the Minister's made via regulations and this bill would still satisfy the test. And as we have read in the Senate committee reports, the Scrutiny Committee and the Human Rights Committee, there are still other concerns regarding these visa conditions still being imposed, for example, the lack of procedural fairness. And so I think what we've echoed is that we have a criminal justice system that responds and protects our community. That's not the job of the migration system. And when government rushes laws, they're often found to be unlawful. And so we should avoid having to go to the High Court again and subjecting people to these really punitive conditions when the court's being clear this is unlawful. So we shouldn't rush these laws and subject people to such conditions.
Okay, and finally, Rax, do you have anything you'd like to add in terms of that constitutionality issue?
We are also not constitutional experts, so defer to the comments of the Law Council. But what I would like to make clear is that there is several questions of constitutionality, not only in regards to the bridging visa conditions, but also in terms of Australia's ability to remove a person to a third country and the purpose of that removal and the purpose of reception facilities in those third countries. I can't give you a definitive answer today, Senator, because we haven't had proper time to really consider the breadth and the depth of those issues, particularly given we are not constitutional experts. But what I would, state for the committee to consider is that there are several questions of constitutionality within this bill.
Okay.
If I could just add to my earlier comment, it's not only constitutional challenges that might render some of the provisions in this bill unworkable. There are potential challenges in other areas of law, so tort law, for example, that might mean that the bill doesn't operate in the way that it's anticipated to operate. And this is another one of the problems with the bill being so rushed, is that these really complex legal issues just don't have an opportunity for the kind of examination that they really require.
Okay, understood. Can I ask each of you, and we'll do the round robin again if we can, just to give your thoughts with respect to how the current drafting of the bill deals with the family unit. So you can have, and I'm sure all of you have dealt with cases where you perhaps have a family unit where there's an adult whose refugee status has perhaps been recognised, but then there's an adult whose status hasn't been recognised, and then you've got the complication of children. How does the bill, from your perspective, apply to the family unit, and what are the risks of a family unit being the subject of separation and being disunited through the application of the provisions of the bill? I'll go to the Refugee Council of Australia first.
Our position is that it doesn't actually contemplate anything about family unity within the current provisions of the bill. The way it could be enacted would actually force the separation and the permanent separation of family. I think, as we said, the who it applies to is broad and far-reaching. It could apply to one parent who would then be forcefully removed from their children and partners. A number of people that would be subject to this have actually spent their childhoods here. They've grown up in Australia, they've spent their formative years here, so they have siblings, parents, friends, community members. They would be separated indefinitely and permanently. So I think that it doesn't give sufficient consideration to how it would actually purposely and forcefully separate families. And I think other colleagues would be well placed to discuss some of the impacts on children, how children, if there was a solo parent home or both parents were coerced to these third country removal or faced, again, indefinite detention, what would happen to minor children under their care? And that, again, isn't appropriately contemplated in the current legislation.
Okay, the Asylum Seeker Resource Centre, please.
Thank you. We echo the comments of our colleague at Refugee Council that there's nothing in this bill that protects family unity or the best interests of the child. And there's case studies in our submission highlight a number of ways that families will be impacted and torn apart, including parents separated from children, partners separated from each other. And that is primarily due to the broad nature of this bill. It has been purported to only apply to a limited group of people, bridging visa holders, but it actually applies to anybody who becomes an unlawful non-citizen. So if your visa ceases, expires, is cancelled, you could be sent to a third country that is part of these reception arrangements. And there's no regard to how long you spent in Australia, the community you've built, your family members here, and that you would be permanently separated and not able to see them again. And we see this playing out for our clients who are BVR holders, but also people who are seeking ministerial intervention on rolling bridging visa ease, people who were medically brought here for medical treatment from Nauru. And as Bevu said, people have been living in Australia for years. They've got on with life. They have married, they have had children, they have established themselves. And this bill doesn't contemplate any of that and the significant impacts that will reverberate, not just for visa holders, but for their families who are Australian permanent residents and Australian citizens. So it's a very concerning part of the bill.
Okay, thank you. Rax?
There's no protection of family unity in this bill, and further, there's no protection of the rights of children in this bill. Australia has a track record of acting in opposition to the best interests of children when it comes to offshore processing, and it is clear that we are going to see that again under this bill.
Okay, and the Cowdall Centre.
I would also echo the comments of my colleagues, especially in relation to the best interest of the child. This is an obligation that we have under our international human rights obligations, and it's clearly not respected in this bill. One of the most concerning aspects, I think, is the automatic nature of the cessation of visas. It's not clear how quickly people would be removed after their visas ceased under the proposed provisions. There is a comment in, I'm not sure if it's the second reading speech or the explanatory memorandum, that people who have children in Australia who would be affected by a removal would have access to ministerial intervention. But given we don't have any clarity about the amount of time that would be available between the cessation and the deportation, or any sort of warnings other than that the person would be told, but we don't have any information about the nature of the information of the notice, it could be that they're deported before the minister has the opportunity to intervene. So there's a really serious concern that there's absolutely no safeguard at all available.
Okay, thank you. In terms of what the bill says around third country reception arrangements, is there anything in the bill that provides any criteria with respect to the selection of a country as a third country, or as a country that Australia might enter into a third country reception arrangement? If I can ask the Refugee Council of Australia first.
No, the third country reception arrangements, as we've all stated, it is these unknown or undisclosed countries. We have heard, through some of the media commentary, countries like Nauru discussed, but there is unfortunately no limitation because there are no criteria. There's no guarantees or safeguards in place for what kind of reception would be available. And I think as a number of us we've been talking about detention, because there is no safeguard to prevent people from being detained upon this third country reception. There's no requirement for any kind of durable visa or durable solution, but also no requirement for a temporary visa for people to enter into these places. So they could go into these reception arrangements where they are then detained, and there would be, again, no oversight, no transparency or accountability about what happens to them. They could be held incommunicado without any kind of oversight as to the conditions they face. And again, that huge risk of them being returned to places of harm, including persecution or death.
The Asylum Seeker Resource Centre, please.
Thanks, Senator. And I won't repeat everything that we've just heard from Rebecca. Just the short answer is no in response to your question, because with the third country reception arrangements, there doesn't even have to be a guarantee or any provision that they're a signatory to the Refugee Convention, in addition to everything else that Rebecca has listed. So, no, there are no provisions.
Rax?
Echoing our colleagues and also drawing your attention, given the previous question, to the fact that they also don't need to be signatories to Convention of the Rights of the Child, ICCPR, any of our other international obligations that we really need to be protecting, particularly the Statelessness Convention. Also, there's just no requirements in this bill that is going to ensure that the human rights and just the basic moral values of humans that we return or place in these third countries will be protected at all.
And the Cowdell Centre for International Refugee Law.
Thank you. I echo my colleagues. There are no protections. There are absolutely fewer protections for the third countries envisaged under this bill than are under current regional processing countries. Under the existing legislation, Section 198AB3AI has requirements that non-refoulement obligations be considered before a country is designated as a regional processing country. That same requirement is not found in relation to the third country resettlement options that are envisaged in this bill. And just from an international law perspective, that doesn't mean that Australia is off the hook under international law. There are a number of precedents that are referred to in the human rights assessment of the bill. But in addition to those, there are two cases, one from the Human Rights Committee, AS in Italy, and another from the European Court of Human Rights, which is HERSI, which both specifically state that states are liable for sending people to a place where they know that they're at risk of harm, or for failing to render assistance when people are in a situation of risk. So it's definitely worse than the current arrangement, which is already bad in terms of protecting people who are sent there, and it puts us at very serious risk of violating human rights obligations internationally.
Okay, the Law Council of Australia, and I'm assuming none of you have had the opportunity to read the Law Council of Australia's submission. I'm still working through it myself. Their recommendation 14 states this: the bill should specify that foreign countries agreeing to accept returnees under these new arrangements must meet minimum standards, including being parties to, at a minimum, the Refugees Convention and the International Covenant on Civil and Political Rights, not having or carrying out the death penalty, and committing to maintaining the privacy of any personal information of returnees as disclosed as part of the removal process. I'm interested to get your views with respect to those criteria and whether or not there's anything else, noting that the Law Council of Australia's overall recommendation was that the bill be withdrawn, but they have then elaborated on certain amendments from their perspective that would improve the bill. If I could give each of you an opportunity to respond to that list of criteria and whether or not there's anything else that needs to be considered around the process, if you like, of determining whether or not Australia should enter into a third country reception arrangement with another country. So if I could go to the Refugee Council of Australia first.
Thank you, Senator. I would have to disagree with that being sufficient. in terms of some of those arrangements. Australia is signatory to all those things, and Australia is trying to send people to these third countries. So if we had, we're assured that all the country that people were being sent to was signatory to all of the international instruments that Australia was, what would prevent them from returning people to harm, to removing them to other places? So I think, unfortunately, that's insufficient. And the international treaties and those instruments are, of course, very important, but there's also aspects, I think that was highlighted earlier, that if a country, for instance, if it's not safe to be someone from the LGBTQ plus community and someone is sent there, even if, again, the country perhaps is a signatory or doesn't, there aren't perhaps criminal justice kind of interactions with when for someone if they are gay, if the community has particularly strong feelings about people who are gay and someone is sent there, and then that information is known because it's been disclosed, again, because of the lack of protections in terms of the disclosure of information, that would put people at risk as well. So it's not just those international treaties and instruments that are necessary. And yeah, I would again, Australia is signatory to all of those and more, and still is doing this.
Okay, the chair's looking to share the call. So if any other witnesses have anything additional to add to that, I'll go to the Asylum Seeker Resource Centre.
We agree this bill isn't salvageable, and in addition to how Australia would actually monitor and know whether a country was complying with its minimum human rights standards, it goes to your earlier question about unity of family, best interests of children. People are going to be uprooted from their lives in Australia, and that would have serious repercussions that would breach their human rights, regardless of whether the third country has signed to a treaty or not.
Okay, thank you. Rax?
Senator, I agree with my colleagues, and I think what I would stress is really what is the purpose here. The purpose was brought to Parliament in order to remedy what was pertaining to community concerns around certain individuals being in our community. And RAC's position is we absolutely cannot accept that the only viable option is to send people to a third country. And so, therefore, even with these amendments or proposals, we just could not support this bill in any of its capacity.
Okay, and finally, the Cowdor Centre, please.
I concur with my colleagues. I don't think it's possible. I mean, given the rushed nature of the bill, it's just not possible to entertain any kind of amendments. There are so many variables that we've all raised in our statements and responses to your questions so far that these simple amendments don't remedy those concerns.
Okay, thank you. Thank you, Chair.
Thanks, Senator Scarr. Senator Shoebridge, you have the call.
Thanks, Chair. Thanks all for assisting us at such short notice and in such obviously inadequate time frame. My first question will be to Ms. Bachani. Buruz, you've had the experience of being sent to a third country by this government, by the Australian government, without adequate protections. Can you very briefly just describe your feelings when you see the government trying to do that again?
Thank you very much for the question. I think it's very important. It's shocking, to be honest, when I think about it. It's like the first time when I found myself in Manus Island and I didn't have an idea about it. And so I think it's shocking. And I'm sure will be shocking for other refugees too. And one point is really important, that refugees already have been separated from their families. Once they left their countries, they cannot go back. It is impossible to go back. So that means they lost their families or a big part of their families. And when they came to Australia, many of refugees separated from their families even here. And there have been many cases that some refugees were in Nauru, the other part of the family were in Manus or in Australia. And now this policy will damage people again. And that's, I think, when I think about it, I cannot believe that Australia is going to do this after all of these years that we hear many tragic stories about refugees. And now, after more than a decade, we see that Australia is going to even make it worse.
I mean, in Manus, the conditions were appalling, but there was some kind of payments and sustenance, minimal medical provisions provided. Could you imagine the government would having the power to send someone like yourself to a third country where there was literally nothing? I mean,
That is, I think, an excellent question. So, and my experience in Manus Island, later I was in Port Moresby, and of course I met many refugees and heard many stories, is what Australia has done to banish refugees to be out of sight and out of mind. And of course, for refugees who were part of LGBTQ community in Port Moresby and in Manus Island, they always had, they suffered more. They were not safe because the law in PNG didn't recognize their rights. And also in terms of medical treatment, having access to medical treatment, of course, PNG was a poor country, so we couldn't have access to medical treatment. And in many cases, in many stories, because PNG was not capable or was not didn't have that capability to support refugees. And we experienced so much violence by, of course, Australian government and the system, but in the same time from PNG's side. And that still continues for more than 30 refugees who are in Port Moresby now. So that's why I am sure that sending refugees to a third country will cause a huge tragedy for refugees. Australia already has done that, you know, and of course, we can talk about it in many ways, like open the way to corrupt the system. You know, we hear many stories about the companies, security companies who work in Manus Island and Nauru. We hear many stories of IHMS, the medical center, about the contracts, all of these questions that I'm sure you know better than I do. But then based on my experience, without doubt, sending refugees to a third country will create a tragedy.
Thanks, Boris. I might just go to the ASRC. You, I think, I understand, still have some contact or some information about what's happening to the people who have now been abandoned after the disastrous Manus Island detention arrangements. Can you speak to the situation of people who get abandoned at the end of one of these arrangements? I mean, because there doesn't seem to be an ongoing obligation to provide any sustenance. What's the experience with PNG? Yep.
Thanks, Senator Shoebridge. The experience from PNG is absolutely devastating. There are about 40 men and their families who are still there after over a decade. You heard from Baruza's testimony the conditions that people were forced to endure, and believe it or not, things have actually gotten worse. We saw last year that any support was withdrawn, so that meant that people weren't able to access the adequate support they need. We are in contact with most of the people who are still on the men who are on PNG, but some of them are too unwell to even engage with ASRC. We try and maintain contact with them, but they're so unwell. We recently did a survey and we spoke to those who are in contact with, and 100% of them displayed significant mental trauma and mental health conditions, as well as physical health conditions. Because something goes untreated there, it just compounds and compounds and compounds after over a decade. So it's an incredibly harmful and desperate situation. And we've seen that the only thing that would help would be medical evacuation. It's what doctors have called for. It's what many politicians have also called for, but we haven't seen that. And this is why this bill is so dangerous, because there are no timeframes around how long someone will be sent somewhere. We don't know what will happen to them. We don't know where they'll be sent. And we have this very human experience at the moment of what people are subjected to when they are exiled offshore at the moment with the 40 men who are there. We are in daily contact with them, and the situation facing them is really, really dire. So at the moment there has been some reinstatement of services, but sometimes they get it, sometimes they don't. They turn to the hospital, they can get treatment, or they don't. So it's this continued uncertainty, this continued limbo and continued harm.
And I suppose it's with understanding that history of harm, knowing the harm that's been caused to people by removal to Manus, by removal to Nauru, that might explain why the government with this bill has tried to remove all legal liability for the harm. And the immunity provisions in this bill seem to be of an extraordinary nature. Maybe I'll start with you, Jana, and then work our way through about your views about the immunity provisions.
Yeah, look, it's always hard to try and predict or get inside the government's head as to why they are doing something. But we have seen, there have been damages that have been paid out to people on Manus, so we can only assume that they are trying to preempt that, knowing that harm will be inflicted, and then trying to preempt and have any immunity to that. But happy to go to other colleagues as well to give them a chance to respond.
What about RACs?
We're not taught experts, Senator, but we would like to just reflect on the significant harm that has been documented, proven, established, claims established into the millions and millions of dollars for people that were subject to processing. Now, this is going so beyond processing, because we are dropping people off and we are abandoning them in a third country with no ability to reflect on how they're being treated, with no processing promises. That was sent and established under offshore processing. So we would submit that is of significantly more concern, given that this transfer of people to a third country is without any purpose, and they'll be left there.
Yeah, and indeed, 11B, the proposed addition to 198 AD, just says no civil liability incurred by an officer or the Commonwealth in relation to any act done or not done. And then if you read B, C, D and E, none of that even requires good faith. It can just be any action they do in relation to regional processing or removal. None of it even, apart from subsection A, none of it even requires good faith. That seems quite extraordinary. Does Rax have a view about that?
I can see my colleague at the Caldor Centre is ready to jump in, so I would defer to her.
Caldor Centre then, yeah.
Thank you, Rax. Look, I find these civil liability provisions incredibly concerning. In a past life, I was involved in the litigation regarding people who were in offshore detention around 2018. That was leading up to the passage of the Medivac Act, and the Labor Party and other parties and independents all joined forces to have the Medivac reforms passed because of the massive amount of litigation that was happening regarding people who were being harmed in offshore detention at that time. I can see that there would be quite significant, complex, lengthy litigation trying to determine what good faith means and whether that was being exercised in any particular circumstance, where that's a requirement for the immunity provisions. Obviously, there are certain aspects of the immunity provisions where good faith is not an element. But I think rather than, I don't know why they've included these immunity provisions. I don't know why they feel like they need to be able to do things that they require immunity.
You might speculate that based on the history of Nauru, based on the history of Manus, they know it's going to cause harm and they want to avoid compensation claims or accountability. I mean, that is, the history proves that, doesn't it? That will cause harm.
The history is very clear that harm is caused, and the Médecins Sans Frontières report that was published at, when they were removed from Nauru was quite strong regarding the impact of indefinite offshore detention and the mental harms that it was causing people, the uncertainty of their protracted, uncertain situations was causing quite significant harm. But aside from the motivations, which I won't speak to, I won't speculate, the litigation that will stem from these potential provisions will be very complex. The litigation that I was involved in starting in 2018, some of it started earlier in 2017 and 2016, some of it's still ongoing. So that's 6, 7, 8 years later, these cases that were commenced just for people to get access to urgent medical treatment is still taking up court time. It's still taking up legal costs, both on behalf of the Commonwealth and generally the lawyers are working for free for those people who are bringing the claims. But it's just to flag that if it is trying to prevent litigation, I fear that will be unsuccessful, and instead there will be quite lengthy litigation trying to clarify the provisions.
Could I just, I don't know if anybody else want to comment on that, because I might move to another point.
You've only got 2
The
minutes.
third country, the new power to enter into agreements with third countries to basically bribe third countries to take people seems to have no limitations about refoulement, non-refoulement, no requirement that they be a party to the Refugee Convention, and no requirement under this legislation that arrangement actually provide any kind of rights for the people who are removed there. Would this permit the government to enter into an arrangement with a third country? That third country could then determine to literally jail people on arrival, and it would still be potentially covered under this bill. I might go to the ASRC first.
That's right, Senator. There are no provisions for or safeguards for people who are removed to third countries. So anything could happen to them there. They could be held in detention. In fact, the bill acknowledges that that's a possibility. There could be chain refoulement, where they are sent on to another country in breach of their protection rights. And I just wanted to come back to that previous question you were talking about with civil liability. The immunity provisions are so broad, it could also prevent any litigation around people's unlawful detention in Australia while they are awaiting removal to a third country. We run those types of cases, habeas cases at the ASRC, and if we had not commenced those proceedings, people would continue to be subject to years of detention. It takes litigation to get people out of detention, sadly. And those immunity provisions would prevent people not only accessing their rights to liberty, but also their just compensation for years of trauma, because detention leaves a permanent and sadly lasting mark on people where if they struggle to rebuild their lives. ASRC recently commenced a class action so that people could access this compensation for their unlawful detention. And the government is seeking to limit their liability when they should be held accountable.
Senator Shoebridge, we're due to go to the next witness.
All right.
One more question, I think, on indulgence.
The
colleagues will let you put that, and then we'll have to move on.
Well, then I might just put this to the panel. It seems that this would permit the government to enter into a third-party arrangement with Nauru or Papua New Guinea, where we know that there's been incredibly brutal conditions. But it could enter an arrangement with Iran or China or Russia, Cambodia, literally any country that they could bribe to take people, subject to any condition that country wants to impose upon it. That can't be how this law operates, can it? I might go to the Caldor Centre.
According to the bill, there's no rules.
No rules.
There's not even a requirement that a formal arrangement be put in place, as there is currently with regional processing centres.
Sorry, just literally deporting people from the country with no rules. No rules.
Not that I can see in the bill.
Bloody hell.
As we've said, this is very rushed. There may be stuff in there that we have missed. There may be stuff in there that is intended to be in there that didn't get in there because it's rushed. But it doesn't seem that there's requirements as there are for regional processing centres.
I think my time has expired.
It has. I'm sorry, Senator Shoebridge.
Thank you all. And again, of such short notice, complex legislation, such traumatic histories, and particularly to Mr Bachani, but to all of you, thank you so much for your assistance.
Thanks very much, Senator Shoebridge. Thank you very much for appearing today and for your submissions or evidence that you've provided to the committee or will provide to the committee. We appreciate it. That's all the time we have. Thank you. I think if it's okay, we might adjourn briefly before we go to the department, but we'll get the department to come up to the table in the meantime. We'll just have a very quick adjournment. Thank you. The committee will resume its hearing, and thank you very much. I now welcome representatives from the Department of Home Affairs and the Australian Border Force. Thank you for taking the time to speak with the committee today. Information on parliamentary privilege and the protection of witnesses and evidence has been provided to you and is available from the Secretariat. I remind senators and witnesses that the Senate has resolved that an officer of a department of the Commonwealth or of a state shall not be asked to give opinions On matters of policy, shall be given reasonable opportunity to refer questions asked of officers to superior officers or to the Minister. This resolution prohibits only questions asking for opinions on matters of policy and does not preclude questions asking for explanations of policies or factual questions about when and how policies were adopted. For the Hansard record, can I ask you to please state your full name and the capacity in which you appear today? Hi, Ms Foster, we might start with you.
Stephanie Foster, Secretary, Department of Home Affairs.
Thank you.
Claire Sharp, Group Manager, Legal Group.
Thank you.
Kevin Cunnington, Assistant Secretary, Legislation.
Michael Burke, First Assistant Secretary, Immigration Policy.
Thank you.
Sarah Nicholson, Assistant Commissioner on Short Detention.
Thank you.
Michael Thomas, Group Manager, Immigration Compliance.
Sandra Jeffrey, Assistant Commissioner, Immigration Compliance Operations.
Andrew Kiley, First Assistant Secretary, Refugee, Humanitarian and Settlement Division.
Thank you. Thank you for all being here today. Ms Foster, do you have an opening statement you'd like to make?
Senator, I just want to... I'm conscious that the committee will want to use the limited time that they have for questions. There were just a couple of points that I wanted to make for clarity as we started.
Thank you.
The first, just a general statement that clearly a robust legislative framework is critical for the management of the migration system, and there is no more important element than decisions on who may come to Australia and who has to leave. This legislation does not expand the cohort of people who are eligible for removal. Australia does not return individuals to countries in respect of which they have been found to engage Australia's non-refoulement obligations, and this bill would not change that. This bill does not change the existing duty to remove set out in Section 198 of the Migration Act, and it does not change the protections established by the Migration Act for non-citizens to whom Australia owes protection. If a person has a protection finding in respect of a country, the duty to remove, as set out in Section 198, does not require removal to that country. The bill does not change Australia's commitment to complying with its international law obligations. Australia has a long-standing bipartisan commitment to non-refoulement. Individuals who face a fear of persecution or harm in another country are able to apply for a protection visa, or if they are barred from making a protection visa application, can seek ministerial intervention.
Thanks, Ms Foster. I appreciate that. We'll start questions with Senator Patterson.
Thank you, Chair. I have some factual matters I want to go to in a minute, but I just want to start at a high level. What would the consequences be if this bill did not pass?
So, Senator, I think there are three fundamental things that this bill is doing. The first is to reflect in legislation the revised test that was established by regulation following the High Court's decision in YBFZ. And whilst that regulation is valid and in effect, we need to mirror that in the legislation. The bill assists us in removing impediments to removal. I've just made very clear that the cohort eligible for removal and the provisions around removal are not changed by this bill. This actually assists us to exercise our obligations under the Migration Act. And finally, it assists us in the management of the BVR cohort. And Ms Sharp can add some detail to this, but it clarifies provisions around our capacity to use spent convictions, and it allows us to reassess protection visa findings. This is all about enabling us to give effect to our obligation under the Migration Act to remove people who no longer have a right to stay in Australia. And as I said in my opening statement, the capacity to do that is critical to the effective management of a migration system.
But we have had some witnesses say that because the government has already issued regulations in response to the High Court's decision that allows electronic monitoring and curfews to be reimposed, that the bill is not necessary, and you've just said the regulation is valid and in effect. So what would the consequences
for that regulation and the control of those people in the community be if this legislation does not pass?
Senator Claire Sharp, the regulation establishes the mechanism by which electronic monitoring and curfew can be imposed if the new community safety test is met. As some of the witnesses earlier referred to, Section 76E of the Migration Act allows a person who's had electronic monitoring or curfew or one of the other prescribed community safety conditions imposed to make representations to the minister as to the reasons why they should not be imposed on them. If we don't make this Act amendment, what we've got is a reference in Section 76E to the old test, so it'll be sitting out of alignment with the regulations. That's, at best, from a legal point of view, very untidy, and at worst, I think, introduces uncertainty into the framework that we'd like to avoid.
Uncertainty which would cause there to be questions about the validity of those ankle bracelets or curfews?
I think having that misalignment could cause questions to be asked about what test should the minister apply at that second stage consideration. So, as I said, we very strongly believe the amendment to Section 76E should be made.
So there is a risk if this bill does not pass, and particularly if it doesn't pass properly before the Parliament rises for Christmas, that in the intervening period before the Parliament returns again next year, if the Parliament returns again next year before the election, which we don't know, that curfews or electronic monitoring that has been imposed by this regulation could again be found to be unlawful and people could be free in the community without restriction.
I think the bigger risk is more to do with the minister. We want the minister or their delegate to take decisions under Section 76E promptly, and not to have that procedural fairness mechanism is a really important part of the system, and we would maintain that visas granted pursuant to the new regulation are valid, but we'd be very concerned about people not having access to the procedural fairness mechanism, applying the correct test as dictated by the High Court. Would you like to add anything to that?
I think, as Ms Sharp was saying, it is important to note it's the initial decision to impose that is made under the regulations. The alignment in 76E is a post-decision element where it is important, as soon as practicable, for that to be aligned so that the same test is applied on that second stage decision, the procedural fairness decision.
Yes, certainly understand why that's desirable, but what I'm trying to get you to clearly put on the public record, given that the government said that this bill is necessary for public safety and needs to pass swiftly, is what the adverse consequences for public safety would be if this bill does not pass.
Maybe I'll try again. As you are familiar with, this is a heavily litigated area.
Indeed.
I think we're very careful to ensure the Migration Act is very clear in the way it imposes requirements and duties and processes. And should we be faced with a situation where the test in the regulations and the test in the Act are out of alignment for a long period of time, I think there could be people, obviously not the Commonwealth, calling into question the effectiveness of the regime.
Legally calling into question.
Correct.
Yes.
Make challenging decisions and trying to... I don't want to at the table in any way sort of suggest any cause of action that I think is there, but in a space as heavily litigated as migration decision-making, of course, we do not want to open up any gaps in our framework.
The passage, to put it in the positive rather than the negative, the passage of this legislation reduces the risk that a legal challenge to the validity of these restrictions would be successful.
Correct.
Thank you. Okay, moving on to some factual matters. Since the YBFZ decision invalidated the previous restrictions on NZYQ affected detainees, how many have had electronic monitoring conditions reimposed via the new regulation?
Senator, 10 people have had either EMD, curfew or both reimposed.
So 10 have had electronic monitoring or a curfew or both?
That's correct, Senator. So less than 5 of those 10 have both. The rest have just electronic monitoring.
Can you break it down for me? Like, how many only have electronic monitoring? And I'll ask follow-up questions.
Senator, because we're talking about such small numbers,
yes.
Again, so it's less
Give
than 5.
me as much detail as you can.
Both. So less than 5 people have both electronic monitoring and curfew.
No, that wasn't my question. I'll come to that category later. I'm starting with just electronic monitoring. So how many just have electronic monitoring?
So it's the balance of that. Less than 5 out of the 10.
Okay, so less than 5 have electronic monitoring only. Good.
No, sorry, have both.
I'm not asking about both. Please don't answer questions I'm not asking. I'll come to that in a moment. I'm going to work through this sequentially. How many are subject to only electronic monitoring?
So, Senator, the reason Mr Thomas is answering you in the way he is if he gives you that definitive number, then he is also answering the question about what the number less than 5 is.
Okay, I understand the restrictions placed on you. Just provide what you can provide. And I'll ask you these questions sequentially and you tell me what you can tell me. So, how many are subject to electronic monitoring only?
So, of the 10, less than the full 10.
This is very confusing. Okay, let's start the other way around. So, there are 10 who are subject to both electronic monitoring and curfews.
No, so there are 10 that have one or both of electronic monitoring or curfew in total.
Right.
So 10 people have the additional.
So how many have curfews only?
So that's that less than 10 number of the total, because there's less than 5 of those.
I understand. Normally you're willing to give me numbers above 5.
It's because there's only 2 numbers in that breakdown of 10. So if I give you the...
If you tell me that 7 are subject to a curfew, then I'll know that 3 are subject to electronic monitoring. Okay.
And sorry, I should have explained that better at the start.
Sure. Okay. All right. So there are 10 people subject to restrictions of any kind, of any of these 2 restrictions in the community now.
Correct.
How many were subject to restrictions before the YBF said decision was handed down?
So there were 162 at the time of the YBF decision that had, again, either electronic monitoring, curfew or both.
How long ago was the YBF said decision? Remind me.
It was the 6th of November, Senator.
Right. And so in the 3 weeks since then, after the reg was issued to remedy the court's decision, only 10 of those 162 have had some restriction reimposed on them?
So far since the ruling, we've assessed 48 of those cases.
Yep.
And of those 48, 10 have had conditions reimposed. We are working through the remainder of the cohort. Given the nature of the new test and its additional complexity, it has taken some time to take the cohort through to the delegate to make that assessment and decision.
So you've only been able to consider 48 of the 162. You haven't even got on to the other, what's that, 104?
It's an active process, Senator. We're working through
114, I think it would be, actually. 114. Right. I suspect I know the answer to this question, and it's going to be something less than 5, but let's see how we go. How many of the 12 murderers are subject to one of those conditions?
Senator, I don't have that particular breakdown with me.
Yeah.
Just with the time we've had, that's the breakdown I've been able to pull together ahead of this.
I'm sure the Minister would have asked you that question.
He hasn't, Senator.
The Minister is not interested how many of the former murderers?
I have the breakdown with the previous conditions, but with the new group, the 10, I haven't mapped that for today with the data against
Sure,
the
but
previous
wouldn't,
group.
I mean, imagining myself in that role as a possibility in the future, I would have thought the first question the Minister would ask the department is, how many of the murderers have restrictions reimposed on them? Please prioritise the murderers. How many of them have restrictions reimposed? He hasn't asked you that question, or his office hasn't asked you that question.
Senator, we're working through the...
I know you're working through it, but that's not my question. My question is, has the Minister or the Minister's office asked you how many of the 12 murderers had restrictions reimposed? And the answer is?
No, Senator.
Right. Has the Minister asked you how many of the 66 sex offenders have had conditions reimposed?
No, Senator, we haven't had a discussion about the breakdown of that cohort yet, as we're still working through them.
I'm astonished that the Minister isn't curious about that. How many of the 97 people convicted of assault have had those conditions reimposed on them?
Senator, I don't have that breakdown with me.
No one here at the table has that breakdown?
No, Senator, if I could just give some context that the Minister knows that we are working through the cohort from the most serious risk to community safety. And so he has assured himself that we are prioritising those cases which carry the greatest risk.
Right, it's just not asking whether you've done anything about the murderers or sex offenders. So let's go to the 48 So 48 you've assessed, 10 have had the conditions reimposed. So that's 38 who have not had conditions reimposed.
Sorry, so there's just one other. The Minister, in tasking the way the new test was imposed, we did advise him that it would be significantly more work intensive to take each case through, and he did engage very clearly with us on the order of grouping of offence types he wanted us to work our way through, starting with the sex offenders and then those who may have had criminal offending relating to domestic violence, who may have had an AVO in the past. He's very actively engaged with us by cohort. I think what Mr Thomas is reflecting is that he is giving us the space to follow the legal process carefully and the new, much more intensive test to do it properly and get those decisions right.
We, of course, in line with greatest risk to community safety.
We, of course, all want you to get it right, but I'm not sure giving space is the right emphasis given the serious risk to public safety here. I mean, you've only assessed 48. There are 66 sex offenders, so you haven't even assessed all the sex offenders in the 3 weeks since the case is handed down.
So, Senator, I think it's been 2 weeks that the team has been working through this, and as both Mr Thomas and Ms Sharp have said, the test is significantly more stringent to respond to the High Court decision, and we must give weight to the test and work through each case as quickly as we can, but taking into account our legal requirements against that test.
Okay, so if you started with the sex offenders, you've assessed 48, 10 have restrictions. Does that mean 38 sex offenders don't have restrictions?
No, Senator, not all of the 48 are necessarily people with previous sex offending
Well,
history.
Ms Sharp just said that your advice was to start with the sex offenders.
We've prioritised those initially, as well as a few other cohorts.
Well, there are more sex offenders than the ones you've assessed, so you're either not following the Minister's advice and you've gone outside his direction to do the sex offenders first, or you have only done sex offenders.
It wasn't a straight list, it was top priorities, and we're working through those.
Okay, what can you tell me about the 38 who have no conditions who you've assessed and now have no conditions imposed on them? Are any of them sex offenders?
Some of them would be, yes.
Are any of them child sex offenders?
I would say so, as they were one of the ones prioritised first.
Right, so we have child sex offenders in the community with no curfew and no electronic monitoring.
Senator, to be clear, they are still subject to the mandatory conditions on the visa.
Including not being able to go near schools and childcare centres, which is important, and I'm glad to hear that, but they don't now have electronic monitoring or curfew. If I remember correctly, one of the rationales for electronic monitoring was to help enforce those other mandatory conditions about going near schools and childcare centres. So how do we know these child sex offenders who have no electronic monitoring or a curfew are not breaching those conditions?
Senator, just to go back to the test again, each individual was assessed against the test to determine if they pose a substantial risk of seriously harming any part of the Australian community. That was the test for imposing those conditions. In terms of their compliance with the other mandatory conditions, there are other mechanisms in place through things like Operation Aegis to actively engage with and work with the cohort. Again, regular reporting, regular contact to understand.
Sure. Thank you, Mr Thomas. As you know, this is a highly recidivist cohort. I vaguely recall last time I asked you for these statistics that of the 215 at the time who'd been released, 65 had been charged with state or territory criminal offences. This is a highly recidivist cohort. It includes people who've committed very serious crimes. I'm alarmed to know that there are child sex offenders out there who are not subject to electronic monitoring or a curfew right now.
So, Senator, clearly we have an obligation to apply the test that was regulated, and that test was developed in response to the High Court ruling. I think it's also been put on the record that in anticipation or in preparation for an adverse ruling, Ms Jeffrey has expanded the capacity within Operation Aegis by 66% so that we are able to increase significantly our monitoring of that cohort in the context of having a more stringent test.
What kind of monitoring?
I'm just going to share the call after this answer, but we will come back to these questions. So sorry, continue.
Senator, that would include just more contact with the cohort. If we can't do it electronically, it would be face-to-face.
Okay, Thanks, Chair.
Thanks, Senator Patterson. Senator Shoebridge, do you have the call?
Thanks, Chair, and thanks to the Department for coming at short notice. Secretary, how many people are in the different classes of visa, subclasses of visa, who are covered by this legislation? We might deal first of all with the removal.
Could I just clarify? Do you mean covered by the definition of a removal pathway non-citizen, or because as certain provisions within this bill refer to removal pathway non-citizens and other parts of it aren't specific?
I mean those who will potentially be subject to removal to a third country under these provisions.
So, Senator,
just to be clear, you're making arrangements you're putting in place power to have arrangements with a third country with the intent to remove people to that third country. How many people, just use the simplest language, are there on different visa types currently who are potentially subject to that?
So Senator, I'm not sure if you were in the room when I started with a couple of opening comments, one of which was this legislation does not expand the cohort of people eligible for removal. And so Mr.
I heard
Thomas,
that, and so I'm asking the numbers.
And so Mr. Thomas can take you through.
You did speak quite quietly, Secretary, but I did hear that.
Senator, the number of individuals on a BVE under departure arrangements at the 15th of November was 4,452.
Okay, so that's BVE, but is that the only class of visa?
No, Senator, also includes those in immigration detention, both held and community detention. That's 986 in held detention and 193 in community detention as of the 15th of November.
And are there any other visa classes, BVR or something?
And the BVR cohort as well, Senator.
So what's the BVR cohort?
So 246 NZYQ affected individuals on BVRs, as well as 96 individuals on BVRs that were granted before the NZYQ High Court ruling.
So there's 250 people who are affected by that NZYQ ruling, and then more than 5,500 other people as well that are the subject of this. What about people who don't have a visa?
So for unlawful non-citizens in Australia?
Would they also be subject to this?
They're also subject to removal, yes.
So how many people are there in the country who don't have a visa? But that last class?
It's an estimated figure, Senator, because it changes quite fluidly.
What's the estimated figure?
Sorry, bear with me. At the 30th of June this year, there was an estimated 75,400 unlawful non-citizens in Australia. But again, I would note that's a very fluid cohort.
So we've had the government say that this would apply to hundreds of people, but in actual fact, it's more than 80,000 people who this legislation could apply to. That's somewhat more than a few hundred, isn't it?
The figures Mr. Thomas is referring to are the people for whom potentially the duty to remove has arisen. As is currently the case in the Migration Act, the duty to remove would enable removal to the person's home country if there's no protection finding, or removal to a third country. That's already what Section 198 requires of us.
So there's about more than 80,000 people who could be removed to the third country if the Parliament gave the Department of the Minister this power. Best estimate is probably more than 80,000, isn't it, Mr. Thomas? 75,400 people who don't have a visa, 4,452 people on BVE, 986 in detention, another 193 I think entering detention, 246 on a BVR as a result of the NZYQ, and another 96 on a BVR. So when Minister Thistlethwaite claimed that this law would only impact criminals, That was just plainly untrue, wasn't it, Secretary? Plainly untrue.
Senator, to put those numbers into context, there are a lot of unlawful non-citizens that do depart of their own accord. In fact,
sorry, Mr. Thomas, I couldn't hear that.
A large number of unlawful non-citizens depart Australia quickly. So that number I gave you could be people unlawful in the community for 10 minutes, days after their visa has expired. So a large number of those people will depart.
But we had the Immigration Minister come out and say, this is designed to address people affected by the most recent High Court decisions. Of the more than 80,000 people who will be potentially the subject of this legislation, 246 are from the NZYQ. So the other, 81,800, did the Minister just forget those, Secretary? Did you brief the Minister properly before the Minister made the statement?
I think Minister Thistlethwaite might have been referring to Section 76AAA as provided for in the bill, which sets out a cessation event for bridging visa R holders granted to individuals who have been NZYQ affected. And it particularly provides a mechanism so that if the person is granted a visa or right of stay in another country and the person is notified of that event, their bridging visa R ceases by operate.
Secretary, did you brief the Minister, either Minister Thistlethwaite or Minister Burke, that this legislation would be applicable in relation to more than 80,000 people? Had you given either or both of those ministers advice about how many people this legislation potentially covered?
So, Senator, our focus in developing the bill was the cohorts affected by the recent rulings, and I think Ms Sharp has indicated her understanding of what Mr Thistlethwaite was likely referring
of the people covered
to. And so, Senator, as I said at the start, the number of people who fall within the definition of eligible for removal is not changed by this legislation.
Did you, my question though, Secretary, hasn't been answered. Did you inform either or both of the ministers that this legislation covers more than 80,000 people, well outside of the NZYQ cohort? Did you give that frank and fearless advice to the ministers?
We certainly explained what the definition of a removal pathway non-citizen was.
Did they ask, was it 80,000 plus people? Did you tell them it was 80,000 plus people? Did that ever happen?
Yes, Senator, we focused on the fact that this bill would allow us to give greater effect to our obligation to remove. It's my understanding that ministers have an understanding of the broader cohort. I did not specifically say there are these different categories.
I understand from your answer, the short answer is no, there wasn't that exchange with either ministers, but you think that they may have that knowledge. But they may have had that knowledge.
But you do that
They
all the
may
time.
have had that knowledge through some other form. Is that...
So, Senator, what I'm
you
saying is...
You assume that they had that
No, let her
knowledge.
answer.
Was that the...
Senator Shoebridge.
Senator, I've given you my evidence.
Okay, all right. Are there any limitations in this legislation on which countries Australia can enter into arrangements with, as contemplated in 198 AHB? Are there any limitations?
The bill doesn't set out any limitations.
So the country, for example, wouldn't have to be a party to the Refugee Convention? That's not a requirement?
That's not a legislated requirement. Australia is very committed to its international law obligations, and it may be, as a matter of practice or policy, the government may insist on that.
So there would be, just to pick a country at random, Iran. There's no legislative impediment to enter into an arrangement with Iran under this bill. Is that right, Secretary?
So Ms Sharp has just answered that question, Senator.
So you could,
that there is
if
no...
this legislation is passed, the government could enter into an arrangement with, well, Papua New Guinea, Nauru, Iran, China, Russia, literally no restrictions on which countries the government can enter into these third country reception arrangements with and forcibly deport people to. There are no limitations, is that right?
So, Senator, Ms Sharp has answered your question technically. She's also said that the Australian government, and as I said earlier, there is long-standing bipartisan commitment to meeting our international obligations.
Did the ministers, either of them, seek advice about whether or not this legislation was compliant with our obligations under the Refugee Convention?
Senator, we gave them advice that our proposed approach was legal and consistent with our obligations.
If the legislation permits the government to enter into these arrangements for the forced removal of people to countries which aren't parties to the Refugee Convention, are you saying that this legislation is compliant with our obligations, given that they could literally enter into an arrangement with, as you've agreed earlier, Iran?
Senator, you've no doubt had the opportunity to look at the Statement of Compatibility with Human Rights that is included in the explanatory memorandum to the bill. That's signed off by the Minister for Home Affairs, and it concludes that the amendments in the bill are compatible with human rights so long as policies, practices and procedures are in place to ensure that the powers provided in these amendments are exercised consistently with Australia's human rights obligations, including removal to third countries.
None of these policies, practices or procedures are in the legislation, are they? I'm asking about the legislation. So if there are a bunch of other things done apart from this legislation, then it may be compliant with human rights. Is that what that's what that says?
That
is
a
bunch of other things.
We're making two statements, Senator. One is about what is legislated, and the other is about Australia's commitment to meet its international obligations. And those two things are coexistent, and they are covered in the
And I feel that to not only half quote the Minister, the final sentence in his conclusion on the Statement of Compatibility with Human Rights is, to the extent that the measures in these amendments limit human rights, they do so in order to maintain the integrity of the migration system and protect the safety of the Australian community.
Yes. I think I've read that. Thanks. Thanks. The Secretary, history is a good sort of illustrator of what this is likely to do. There are still somewhat 42 people who were forcibly deported to Manus under the previous arrangements with Papua New Guinea, who have since been abandoned by Australia and have no support in Papua New Guinea. Is it 42? Is that your understanding? People who were forcibly deported to Manus Island and are now in Papua New Guinea with no support from Australia. So 42?
If you're referring to the cohort remaining from the regional processing arrangement with PNG, it is of that order.
I see Mr Thomas nodding. He's good with numbers.
That's our understanding.
42.
Senator Shubridge, I have to wrap you up in a second. Mr Thomas is very good with numbers.
Well, Mr Thomas is. I rely upon Mr Thomas for his numbers. I've not been that genuinely good with numbers. There's no... Australia's providing no support to those 42 people now, or their families or kids. Is that right?
So, Senator, under the regional processing arrangement, Australia has no responsibility for the people transferred, and as you know, the regional processing arrangement was ceased some time ago.
And you're aware that a dozen of those people are in such destitute conditions, such poor health and physical conditions, that they can't even engage with the UNHCR. Are you aware of that?
Senator, I think we covered this in our estimates exchange a short while ago, and Mr Thomas indicated that we had in fact been working with the PNG government to support them, to support those people.
That hasn't changed since that time. Still no support being provided?
So, Senator, I think that was not my evidence. It was that we are providing support to the PNG government to support that cohort.
Well, my memory was no money had exchanged hands, but perhaps that's changed since.
Thanks so much. Thanks. I just thought I might ask, going back to one of the primary questions, Ms Sharp, can you explain what the court decided in YBFZ, and how is the case different from NZYQ?
I mean, sure. So maybe I'll start with NZYQ first.
Yeah, thank you.
NZYQ considered the question of whether a person could be held in immigration detention if there was no real prospect of removal in the reasonably foreseeable future. And in a unanimous judgment delivered on, I think, the 8th of November 2023, the court held that someone could no longer be held in immigration detention for that, and could never have been held in immigration detention in those circumstances. YBFZ was looking at a different matter. It was considering whether the imposition of electronic monitoring and whether the imposition of curfew could be validly imposed. And I should have said in relation to NZYQ, the question in NZYQ turned on whether there was a legitimate non-punitive purpose associated with holding someone in immigration detention when there was no removal, no real prospect of removal. Similarly, in YBFZ, the court was considering whether it was punitive to impose electronic monitoring and curfew on a person, and if it was prima facie punitive, whether the mechanism was reasonably appropriate and adapted for a legitimate non-punitive purpose. In the majority reasoning in YBFZ, the plurality. That's the one. Plurality.
Most of
them. Four issued a joint judgment. I'll say that. And they reasoned that, in fact, the imposition of curfew and electronic monitoring was prima facie punitive, and the test was not reasonably appropriate and adapted for a legitimate non-punitive purpose. That had the effect that all of the electronic monitors and curfews that had been applied had been unlawful.
Thank you. And as I understand it, my understanding is very simplified, but one of the reasons that the court came to that decision was because the test was a negative one, where the presumption was applied to all of the people in the cohort, and essentially the minister had to decide whether they would not be subject to those conditions. And what is being proposed in this legislation is a positive test where a decision would have to be made about imposing those conditions. Is that right?
That's right. The new test is significantly different. If you did a word count, you would see it's substantially longer and more involved. So the former test did require that the conditions be imposed unless the minister was satisfied that it wasn't reasonably necessary.
Yeah.
The new test requires that the conditions may only be imposed if a two-pronged test is met. Mm-hmm. The first part of the test is that the minister must be satisfied on the balance of probabilities that the holder poses a substantial risk of seriously harming any part of the Australian community by committing a serious offence. And then the second limb, if he is so satisfied, is the minister must be satisfied on the balance of probabilities that the imposition of the condition, in addition to the other conditions that are automatically imposed on the visa, which can include daily reporting, requirements not to go near schools, this minister must be satisfied that the electronic monitor or curfew is reasonably necessary and reasonably appropriate and adapted for the purpose of protecting any part of the Australian community from serious harm by addressing that substantial risk. So it is quite an involved test, which explains why a substantial package of documentation needs to go to the decision maker, and that consideration can take quite a significant amount of time.
And this is stating the obvious, but very much for the record, the due consideration that has to be given to that decision is needed to make sure the decision's not invalid later on.
That's right.
Yeah.
In addition to the risk of a constitutional challenge, of course, in any administrative decision, these decisions are open to merits review and judicial review. So, of course, we want to get our decisions right because we strive to apply the law correctly in everything we do, but there are multiple avenues for review as well that we're mindful of.
I'll come back to that if I need to. One of the questions I had was about, I think Ms. Jeffrey or Ms. Foster, you might have alluded to this, but in terms of the other measures the government's taking to keep community safety following the decisions, NZYQ, YB, FZ, you referred to the operation that you're leading. Could you take us through those steps, please? I understand there's been additional funding or increased resources.
Thank you, Senator. Yes, Operation Aegis is a joint ABF-AFP operation particularly dedicated to managing compliance of this cohort. So we have staff in every capital city around Australia who engage regularly with the cohort themselves, but also with the AFP and with State and Territory Police in managing the compliance of the cohort. There's a list of mandatory conditions that are on every BVR visa. So if they don't have electronic monitoring and curfew, they do, for example, have to report regularly, most daily, to the department. They have to advise of change of address, change of employment, and that sort of thing. As we've mentioned earlier, if there's sex offending or child offending, can't go near schools. If there's domestic violence charges or offences, can't go near the victim's family, those sorts of things. So we work really closely with police to ensure compliance with the other mandatory conditions.
Okay. I wanted to ask about some of the panellists from earlier had raised constitutionality issues with the new test. Ms. Sharp, I'm sure that this is something that you would have sought legal advice about in terms of the constitutional validity, without going into the legal advice, because I don't think you are allowed to do that. Has the government sought that advice?
Yes, Senator.
Yeah. And in terms of the test itself, look, I'd hate to put you in a position to say that you're 100% sure about it, but we're comfortable with the advice we've received.
We're comfortable the test reflects the advice we've received.
Yeah, thank you very much. Just in regards to the enhanced removal powers of the bill regarding third country removals, can I ask, we're talking about presumably people who have no right to stay in Australia. Why is it important that we strengthen and streamline the government's power in this bill to allow third country removals for people who've had their visas cancelled?
Thanks for your question, Senator. I think as the Secretary outlined, this bill doesn't change the cohort that's liable for removal. And I think Minister Burke has made clear the government's view is that people that have no legal right to remain in Australia should depart. This bill doesn't change the obligation on the department to effect removal of people. It doesn't change the expectation that people that have no legal right to remain should depart Australia. What it does is it helps with reducing impediments that the department can face in discharging our legal duties to remove people from Australia that have no legal right to remain.
Okay. And you went to this, but I'm seeking to clarify because of the evidence we received earlier. This bill, the bill does nothing to expand the number of people or classes of people who can currently be removed from Australia under the Migration Act.
That's correct.
Okay, thank you. I just have one more question and I'll share the call, Senator Patterson, and I can come back to some other questions in a moment. I wonder whether you were talking about the human rights obligations, Ms Sharp, and they're set out in the explanatory memorandum. Unfortunately, Senator Shoebridge's not here to hear this question, but Australian government has a presumably bipartisan position of complying with international non-refoulement obligations in respect of removal of illegal non-citizens. Despite some of the views that have been put forward today, nothing in this bill changes that obligation.
That's correct. In fact, in some ways it reinforces it. If you look at the way the bridging visa cessation provision set out in section 76 AAA is structured, if a person has applied for a protection visa, then the BVR will not cease.
Yeah.
So if they've got an ongoing protection visa application and then the bridging visa will remain in effect regardless of the fact if a third country did issue them with a visa or permission to enter. And similarly, the information disclosure provisions are very clear that we can't disclose information about a person to a country to whom we've got a protection finding in place.
Yeah. Okay, thanks very much. Senator Patterson, I'll share the call with you and then we'll come back around again.
Thank you, Chair. I just want to touch on these constitutionality issues that the Chair has raised, because I do recall almost exactly a year ago in a hearing like this into the legislation that was ultimately struck down by the High Court, similar questions were asked about constitutionality and similar encouragement or comfort was given about the constitutionality of the previous legislation. Why should we have more confidence as a parliament this time that that advice is correct?
Senator, and I'm not a constitutional lawyer. Everyone will tell you that they're not a constitutional lawyer, but I'm
Neither
not.
am I.
But what I would observe is that the jurisprudence that's emerged through NZYQ and now YBFZ is helping to us to understand better the boundary between the judiciary and the executive and the definition around what functions are considered prima facie punitive by the court, and that additional reasoning in YBFZ has helped shape the approach to the provision.
Sure. Certainly.
Sorry, the Secretary just asked me whether or not when we gave evidence we were providing evidence without reason, and I can't actually recall the date of the hearing relative to
Develop the legislation.
The first, that is true. The test that was... No, actually, it's not true. Sorry. Disregard.
Carry on. We'll strike the record. You're not a constitutional lawyer, but the Solicitor General is, and we were told that the Solicitor General had been consulted on the legislation and had provided advice that it was constitutionally sound. Has the Solicitor General provided that advice again in respect to this legislation?
The Solicitor General has considered the draft regulation and the relevant parts of the bill.
And what is the Solicitor General's advice?
I don't disclose the content of legal advice.
Okay, well, what's the basis of your confidence in the constitutionality of this legislation then?
I think I gave evidence to Senator Green that the regulation reflects the advice.
Right. So you are willing to allude to the advice. The advice obviously says it's constitutional.
Senator Ms Sharp's not able to comment on the content of legal advice.
Okay. I probably won't get much further with that if I persist, so let's go back to some other matters we were discussing before. Ms Jeffrey, you were telling me that the sex offenders now free in the community without any electronic monitoring or curfews will be still subject to some controls by ABF. Could you just clarify exactly the nature of those controls again? I think you said that you would call them.
They are required to call the department.
Yep.
So that would be the reporting condition. But over and above that, we would have compliance officers visiting them as well.
Mm-hmm. So if they comply with their requirement to call the department, call the ABF, what does that involve? Is it a daily phone call? Is it a weekly phone call? What are they required to report on the phone call?
It can vary, but all of the YBFZ caseload have daily reporting conditions if they don't have electronic monitoring.
Okay. And what's the nature of the report they're required to make when they contact you?
They just call into the department. We check on their address, make sure they're still at that same residence so we know where they are, any other welfare concerns or anything like that.
Do you ask them whether or not they've been near a school or a childcare centre?
We'll probably remind them of those conditions if they have those conditions.
How then can you have confidence that they're complying with those conditions?
We work with the State and Territory Police around that.
Mm-hmm. And how do you work with State and Territory Police?
Just that they're aware of the cohort as well, and my case officers in the States will be, working closely with the local police in that area who will be aware.
So police monitoring the movements of detainees?
Together. We work on it together.
Mm-hmm. But are they monitoring the movement of detainees? You don't have electronic monitoring on these people. Presumably police don't either. How do they know whether or not they've gone past a school?
It would only be if it came to our attention.
How would it come to your attention?
Through work with the police.
And that's what I'm asking. How would the police know?
Because they would be aware of the caseload as well.
But then you've just said they're not monitoring them. They can't. They
not
don't
electronically, no.
No. So are they under surveillance?
No, they're not, Senator.
Right. So they're not being monitored.
It would be the same as police interaction with others in the community.
Indeed. But others in the community don't have a requirement to not go near a school. So how can we have confidence these people are not going near schools?
Senator, the offence provision that attaches to that visa condition still applies. So, for example, should someone be seen to be near a school and that's reported to the State or Territory Police, that very clear offence provision, they will have breached their visa condition and they're up for a fairly significant offence.
How would a member of the community or a school or anyone know that this person was a prohibited person who's not allowed to go near a school?
I think that would just be they're observed. In the ordinary way, if someone unusual is hanging around a school, the school may well report that to the police.
Right. How many of the cohort breached their visa conditions?
There's a technical legal answer to that, which you're probably not interested in, but the answer to that is 0 because the visas were...
That was going to be my follow-up question, but we'll come to that. I'm interested in the operational answer first and we'll get to the legal answer second.
So while Mr Thomas is looking for the data, Senator, breaches ranged from small breaches of curfew time, arriving home 10 minutes late, through to more significant breaches.
And
Senator, I've got data as of the 18th of October.
Okay, we'll take that.
So as of 18th of October, the department had submitted 143 reports of crime to the AFP. So we do that where there is a suspected breach for the AFP to further investigate.
So that's 143 instances of crime. That's not necessarily 143 individuals. Presumably could be some individuals committing it multiple times. Do you have the number of individuals?
I don't have that broken down, Senator, by the number of individuals, just the number of referrals, noting that they'll be investigated, not all will result in a charge. And I think we've provided the number previously on Migration Act offence charges, but that was 30 people in total, as at the 18th of October, were subsequently charged with the Migration Act offence.
Suffice to say, there had been, prior to the visa conditions being struck down by the High Court, repeated and significant instances of breaching visa conditions among this cohort.
Yeah, so Senator, that number of breaches relates to the period of almost a year, I think, over which they took place.
Yes, that doesn't give me any comfort. So we've got repeated instances of breaching visa conditions, and that's when we had the benefit of electronically monitoring people, so we could know if and when they breached those visa conditions. I come back to my question about sex offenders near schools. If this is a cohort which is routinely breaching their visa conditions when monitored under other conditions, how should we have any confidence that among the child sex offenders free in the community right now without electronic or a curfew are not also breaching the condition to not go near a school?
So, Senator, as I said at the outset of this block of questions, a good number of those breaches, and I'll see if we can get any breakdown for you, were breaches of curfew, not necessarily breach of the provision to go near a school. We'll try and get you a bit better clarity on that.
I understand that, Ms Foster, but I don't think that's actually a very helpful distinction to draw, because for two reasons. One, we would only know about their breaches of curfew because of the advantage of electronic monitoring, which we now lack. And secondly, someone who is willing to violate their visa condition with respect to curfews might also be willing to violate their visa condition with respect to schools. And because they are now not electronically monitored, we don't know if they are doing so.
And so, Senator, the second point I was going to make was that the conditions have been removed as a result of the High Court decision, in my BF said, and in responding to that decision and the reasons for that decision, we have revised the test that allows us to impose those conditions in line with that decision. And so we are, wherever we can, imposing conditions for the protection of community safety.
Okay. Prior to YBF said, how many visa holders were successfully convicted for visa breaches?
Senator, again at the 18th of October, less than 5 people were convicted of a Migration Act offence.
How many of those fewer than 5 people convicted had a custodial sentence imposed?
All of those individuals received a suspended sentence.
So the other way of answering that question would be zero.
Correct, Senator.
0. Wasn't there a mandatory minimum sentence imposed by the legislation?
There was, Senator, and I think Mr Thomas just indicated that the sentences were suspended by the court.
Yes. So why wasn't the Parliament's clear intention that a mandatory minimum sentence of 1 year imposed when those convictions occurred?
So the sentence was given, the sentence suspended. Yeah. Do you want to answer that?
Yeah, under the Crimes Act, the court has the flexibility to suspend sentences. So it did impose the 1 year sentence and then suspended it in full.
Right. Do you think that it's consistent with the Parliament's intention
Senator, it's consistent with the operation of the law.
Yeah.
Mm-hmm. I don't think that when parliamentarians voted for a mandatory minimum 1-year sentence for visa breaches, that they intended that in every instance where someone was convicted of that they would be immediately released into the community under suspended sentences.
I intended it to be lawful.
You didn't vote for it.
I intended it to be lawful.
You didn't vote for it, Senator
I thought it should be
Shubridge.
lawful.
I think if you told most Australians that mandatory minimum sentences don't actually mean going to jail, they would be surprised.
Senator, I can only repeat, it's operated in accordance with the law.
Indeed. Okay. So how many people have been relieved or had their convictions quashed as a result of YBFZ?
Senator, I don't have that exact figure in front of me. We will need to check with the Australian Federal Police, but I understand it to be slightly above 20, but would need to check that with the AFP for
right, so
accuracy.
That means there would have been 20 convictions.
Sorry, just to clarify, the charges were dropped.
Okay, charges were dropped for 20 people who violated the conditions of their visas.
I'd have to check that number, Senator, but I believe...
Okay, in the vicinity of, I won't hold you to it, on notice giving the exact number, in the vicinity of 20 people's charges were dropped as a result of YBFZ who breached their visa conditions. How many convictions, though, were overturned or quashed, whatever the terminology is?
That constitution thing.
I think we're hesitating because we are not... we would need to take on notice the precise legal mechanism that the conviction of an offence that is subsequently based on an unconstitutional provision, exactly what the legal terminology is, but I think we've already...
I'm not hung up on the terminology,
Okay.
I just want the numbers.
Well, I think we've provided evidence that there were 2 convictions and those would no longer, based on YBFZ, be valid.
Okay, all right. I look forward to the clarity that you can provide on notice. How many community safety orders have now been applied for?
No community safety orders have been filed yet, Senator.
Ms Sharp, as you know, we discussed this in Senate estimates 2 weeks ago, and I was given the impression that we were close and that applications were about to be made. Was the advice wrong that we were close, or is 2 weeks not close?
I think I said in the coming weeks, and I still consider that was correct evidence.
Well, in the coming weeks could be 100 weeks. That would still be in the coming weeks. How many weeks is the coming weeks?
It is incredibly difficult to put a hard deadline on this due to the exculpatory evidentiary requirements that require this intensive documentation review before we file. I do keep very regular tabs on how that process is going. I do still anticipate we'll file in the coming weeks.
That would be good. The 6th of December is the 1-year anniversary since this preventive detention legislation was rushed through. So I ask again, what's your level of confidence that one application will be made for a community safety order in the 12 months following the passage of the legislation?
I don't think I have anything to add to what I've already said.
Fair enough. When did the department commence drafting on this bill?
We don't have the date with us, Senator.
Okay. When I asked you about this in Senate estimates in a more timely way than either of us realised, you said that the department had done extensive preparations. So did the drafting begin prior to or after the YBFZ case was filed?
It occurred prior to.
Prior to the case being filed?
Oh, sorry, no, not to the case being filed, sorry, prior to the judgment being delivered.
Okay, so it was sometime after it was filed and sometime before the judgment was delivered, the drafting started?
Correct.
Did the drafting start before or after arguments were heard in the case?
I really would need to check that. It was started some months ago. I just don't know whether it was started, the hearing was on the 6th of August, and I just don't off the top of my head recall the date we issued our first drafting instructions.
Okay, you probably then won't be able to answer this, but take it on notice, please, when the Minister was first briefed on the drafting of the bill?
Minister Burke was briefed on the YBFZ case almost immediately upon him becoming the Minister. If you recall back temporarily, He became the minister very shortly before the hearing in YBFZ, so he was fully briefed on the case, what was at issue, and operational planning.
Okay, well, how about perhaps on notice when the minister was provided the first draft of the bill?
Yep,
you have to take it on notice. That's fine. Thank you. I've asked you already about the Solicitor General.
And Senator, I think it's important to also note the regs drafting was occurring because the regs is the thing that needed to occur first, was happening earlier than the bill as well.
Right. Well, can you tell me when the drafting of the regs commenced?
Not again. I would need to take it on notice, but I just think we probably will supply you with both dates to give you a.
Thank you. That'll be helpful. I will take all information on notice about the drafting of the regs or the legislation that you can provide, and when the minister was briefed and when the minister signed off on each of those. Chair, I'm happy to share the call and review my questions if that's helpful.
Helpful. Thank you, Senator Shoebridge. We're back to you.
Yeah, thanks, Chair. You asked some questions earlier about the elements of this bill that are required to sustain the regulations, the fresh regulations that have been made for curfews. And I think you said 76E, the 76E provisions. Yep. So is that Schedule 6? Is it all of Schedule 6 that's the bit that's needed?
Schedule 6 is the schedule that relates to the amendments to Section 76E that I was referring to.
Yep. And correct me if I'm wrong, you were, as I understood your evidence was that if there was dissonance between the language in 76E and the test in the regulations, that might create some legal uncertainty and that the purpose of these amendments are to remove that dissonance.
That's correct.
Is that right? The other 5 schedules don't apply to the regulations or or respond directly to that most recent High Court case, do they?
I would say Schedule 3. So Schedule 3 relates to the use and disclosure of criminal history information. That information is critically important, and Ms Jeffrey might be able to take you through why it's so important being able to access and use all available information about someone's criminal history and not be as tied up in the state and territory spent and conviction regime. So that's really important for being able to apply the test effectively.
Right. And just as you do that, Ms Jeffrey, if you could potentially answer why it is that these amendments are both prospective and retrospective and what the intent of the retrospectivity is.
Sure, I'll refer back to General Counsel on that part. But it's really important for our decision makers that are making visa decisions, as well as supporting bodies like the Community Protection Board that provides expert recommendations to visa decision makers, that they can consider all the relevant information about a person's character and past behaviour so that they're making sort of sound decisions or recommendations in relation to community safety going forward. The new test, as you've seen, is really quite a high bar and quite stringent, and they have to make quite complex decisions. So having the full history of the person, including spent convictions, is really important for them. And through our experience of these decisions, the state and territory legislation around spent convictions is not consistent. It's different in each state and territory. Which adds to the complexity, and we're trying to put beyond doubt in this legislation that information can be used.
But Ms Jeffries, the reason why you have provisions like proposed clause 4.2 and the other retrospective provisions of this, is that because you've been doing it already? Is this the current practice?
As I said, we're trying to put beyond doubt that can be used because the state and territory legislation is different.
So to be clear, this is current practice. You're trying. This is seeking to put a legal underpinning for current practice?
Well, a particular challenge we have, Senator, is our systems, information is entered into our systems, many of the spent over time. And so our record of a person's journey through Australia and the interactions, information might have been updated in 2007, then 2012. As different visa decisions are made, different information comes into our system. At the time it comes in, it may not be spent, it wouldn't be marked as spent. A particular challenge we have is then when the decision goes before a delegate, trying to work out which parts of that record are spent now or which parts aren't. And that the rules do vary, and it is diabolically complex to disentangle that and get something that we can 100% with confidence say removes all spent conviction information.
So the answer is yes, this is seeking to validate.
I think the answer is to put beyond doubt and avoid
practice
and to, I guess, most efficiently use Australian taxpayers' dollars insofar as the amount of legal work that would be required for each visa decision to ensure that and put beyond absolute doubt would be very significant.
Are there any current legal challenges on foot that challenge the validity of the department's use of spent convictions or sharing of spent convictions? Are there any challenges on foot?
Not to my knowledge.
But if there were, they would. The intent is to provide legal protection for the department and the Commonwealth.
Yes, it wouldn't necessarily revalidate the actual decision. It's to ensure that the use of that information was not the reason that the decision was invalidated.
So, putting to one side past and current practice, do you say that Schedule 3 is required, you want the powers in Schedule 3 in order to undertake the process set out in the regulations, that will assist the process set out in the regulations, is that right?
For us to be able to assess each case against this stringent test with the goal of establishing risk to community safety, the use of that information is critical.
This is not a trick question. You want the provisions in Schedule 3 in order to, that you intend to use that in conjunction with the recently made regulation-making powers to put in curfews and the like. You see those two as operating together, is that right?
We see them as allowing the delegates to have full information on which to make an assessment about the risk to community safety.
So I was asking which parts of the bill relate to the recent High Court case and relate to the regulations, and so far we have Schedule 3 and Schedule 6. Is that right?
Yep.
And there's obviously other schedules in the bill, but they don't relate. They have a different purpose. They don't relate to this.
That's right. I think, stepping back, Senator, the minister's been very clear that his preferred solution is that people aren't on electronic monitoring or curfew in the Australian community, is that they're removed from Australia as they have no ongoing right to be here.
But we won't recount where they could be removed to. We had that discussion earlier, but the intent is to open up the world for potential third-party agreements. Is that right? That's what the bill does.
Sorry, I'm just challenged by your words, opening up the world.
Any country in the world.
The bill does not set out which countries are or are not possible third country removal countries.
There have previously been legal challenges to decisions of the department to pull families apart, deporting parents and older siblings. I know of at least one case brought by the Human Rights Law Centre. There's nothing in this bill that prohibits the separation of families, children under 18 from their parents or their older siblings, is there?
So, Senator, this bill does not change the provisions that relate to who might be removed, who falls into that cohort. it's not at the point of removal that consideration is taken into account. It's at the point of visa decision, i.e. a decision to cancel a visa.
Well, if people have no visas, or they're on a BVE, or they're on a BVR, and they have children who might be Australian citizens in this country, there's nothing in this bill to reference back to the best interests of the children, before a deportation decision is made, before the 76 AAA process is kicked in. It doesn't have any reference to the rights of a child, the best interests of a child, nothing, does it?
So, Senator, I was just trying to explain that's not the point at which the rights of the child are considered. At that point, the person is we have a duty to remove someone who is in that category.
The decision-making that led them to be at that point, for example, to become on a bridging visa R, almost the entire cohort had a substantive visa that was, or either applied for a substantive visa or had a substantive visa that was refused or cancelled on character grounds. The ministerial directions that govern that kind of cancellation under Section 501, so the current one being Ministerial Direction 110, has as a primary consideration the rights of the child.
And that's 342 of the 82,000 people. So the other 81,800 people, is there any reference, if they have children in the country, is there any reference to the rights of those children before their parents are removed?
Senator, just to be clear, you're referring to the broader group of unlawful non-citizens as well. Those individuals will have become unlawful non-citizens because their visa was expired or it was cancelled.
I'm not asking about them. I'm asking about their kids. Is any regard had to the children before a decision is made to deport their parent to one of these third countries with whom the government enters into agreement?
As Ms Foster and Ms Sharp said, that's taken into account at the point of visa cancellation or revocation consideration around the cancellation, the right.
People may just have an expired visa.
Child. Once that person becomes an unlawful non-citizen because of that account, then they're on a departure pathway and a removal pathway from Australia.
Sorry, are you saying that the best interests of the children were taken into account when people were moved to a BVR visa?
So at the point of their visa cancellation, Senator, or when a revocation request was considered for the cancellation of the visa?
Are you saying that the decision maker had regard and is obliged to have regard to their children?
Yes, Senator. Under MD 110, that is a primary consideration.
And when they move on to a BVE?
It's the same, Senator.
And when they have no visa? When their visa expires and the 75,400 visa expires, is there any regard to their children?
If their visa expires and they enter the community unlawfully, there's no decision or any consideration. And I think we're sort of our job is not to have people disappear into the community as unlawful non-citizens. Our job is just to have a system that allows visa status to be regulated.
And Senator, we make every reasonable attempt to locate unlawful non-citizens and regularise their status, whether that's consideration of a bridging visa or detention and removal.
When those decisions were being made for the 4,400 on BVE, the 342 odd on BVRs, this arrangement wasn't it? There was no arrangement with a third country in place, was there?
So, Senator, we have the capacity when people are on a removal pathway, however they get there, to either remove them to their country of origin or to a third country. That's not changed by this bill.
Although the scope of countries, third countries, who could be the subject of a reception arrangement is impacted by 198 AHB, you've given fresh powers to enter into. That's what Schedule 5 does, isn't it?
Well, they put on the face of the law an authorisation provision.
And so I'm assuming that nobody was when they were making decisions about the 4,500 people on BVEs, the hundreds on BVRs, they weren't contemplating perhaps that those children might be deported to, might be compelled to go with their parents to Nauru or Manus Island.
The BVEs have been...
At the time, because this legislation wasn't in place.
The BVEs that are within scope of the removal pathway non-citizen definition are BVEs that were granted with the departure criterion attached. They were granted with the express intent that the person would be making arrangements to leave Australia.
But not unwillingly to a third country that hadn't yet been identified, subject to an arrangement under this. No one was considering whether or not 7-year-old kid, 8-year-old kid, 10-year-old kid might be compelled to go to Nauru without protections, or Manus or Papua New Guinea without protections, or whatever country. No one was considering that. These children's interests have not been considered. But now there's, 82,000 people who are potentially able to be deported to a third country. Heaven knows how many of them have kids. There's nowhere that those kids' interests are being considered with this legislation, is there? Nowhere at all.
Most of those 85,000, though, can go home to their home country.
Why do you say that, Ms Jeffrey?
Oh,
because many of them do.
Because the majority of countries accept their citizens back.
And Mr Thomas can take you through some of the statistics of people in that category who do leave and go home to their country.
So to give you some context, in the 2023-24 financial year, we had 5,178 individuals return from the community to their home country. So those are the group on bridging visa E's, largely. So we have high volumes of returns, and that's not including from detention. So that, again, that financial year, 2,764 in total. So there were 7,942 total returns or removals.
Which is less than 10% of the cohort covered by this legislation. Less than 10%.
Again, Senator, it's a fluid cohort. It's not a static number that we look at.
I have to share the call in a moment, yeah, but I know you're probably seeking to wrap up your questions.
And just to clarify, those removals are happening under the existing provisions of the Migration Act. The new arrangement that the bill would authorises us to enter an arrangement with a third country. It doesn't authorise the removal. The removal is effected pursuant to Section 198.
All right. I note that the Chair wants to move the call round. So.
Thanks, Senator Shoebridge. I wanted to ask about, first of all, the preparations involved in the preparing for the eventual outcome of the case. I assume that there was the assumption that there could be a few different outcomes, or one of two. So were you preparing for whatever outcome there might be? Yeah.
Senator.
I mean, it's a bit hard to do that, but...
No, we were really conscious that it was such an untested area of law. We were really conscious there could have been multiple different variants of an outcome. You know, we could have had the court finding both conditions were valid. We could have had the court finding one was valid and not the other, vice versa. So we did do extensive preparation, trying to map out what possible outcomes were and what possible regulatory responses might be available should we not be successful in the court.
Okay, thank you. And I was wondering if you can clarify what discussions you've had with the Minister and his office regarding the prioritisation of the NZYQ cohort for decisions following YBFZ for electronic monitoring and curfew conditions. You said before that, I mean, look, to be fair, I think Senator Patterson was trying to seek to separate those cohorts, but what directions have you been given on prioritisation requests?
So looking at the group that had electronic monitoring curfew up until the YBFZ ruling, prioritising those that had sexual related criminal offences previously, those with current orders on them, those that presented particularly high risk to the community, but prioritising the group in that manner to reconsider conditions under the new test.
And I want to go to the issue.
Obviously, there are a combination of factors to consider. One is the nature of previous offending. The other is the assessment around the likelihood of reoffending, therefore the risk to the community. And so it's not a simple calculation.
And Senator, a lot of this cohort have been in the community for an extended time now, so the department is aware of their behaviour, what they've done in the community, and taken that into account as well.
Some of the evidence that has been put to you, but also from previous witnesses about this issue of supposedly splitting up families. I just want to clear this up because I guess what I understood from your evidence was that the consideration of all of those factors occurs when the visa is cancelled, and that means that this bill, or no part of this bill, goes to that part of the decision. That's
right. This bill operates at the point when the removal duty, as set out in section 198, already applies to an individual. This bill does not change who is required to be removed. It simply puts in place an additional set of levers or tools to assist with effecting removals of people who are already required by law to be removed.
Yeah, I think what is trying to be suggested is that this bill replaces an entire migration system, and that's not the case. As I understand from your evidence, Ms. Sharp, this bill deals only with the removal pathway, but all of the other the lead up in terms of decision making around visas, and even our obligations, our international rights obligations, our human rights obligations, our commitment to non-refoulement, that is not touched by this bill.
That's correct.
Yeah. Can I ask then about this number that's been used by my colleague, given by you, Mr. Thomas, just on the number of people in the cohort. We've heard, and we hear this on other occasions, that the bill could affect an extraordinarily large number of visa types. Can you clarify which visa type section 76AAA applies to?
I might do that.
Thanks, sorry.
It only applies to the bridging visa R. So much smaller, because it deals with the cessation of the bridging visa R in particular circumstances.
Okay, and what's the number of that cohort, Mr. Thomas?
On bridging visa Rs, so there were 246 NZYQ affected individuals and 96 individuals on a BVR that was granted prior to NZYQ.
Okay, and bridging visa R, sorry, because I'm not across all the classes, but they would be people who have had a decision about the cancellation of their visa already made?
So all of that cohort are finally determined. They have no more ongoing processes. And for the ones that are NZYQ affected, subsequently, if they're in detention, released and granted a BVR. And for the legacy, so to speak, cohort, it's the same consideration. They're all finally determined and are on BVRs.
And what's the correct term? Unlawful non-citizen?
For that BVR cohort? Just they're bridging visa holders.
They're bridging visa holders, sorry. So what is the...
They're lawful non-citizens.
Unlawful non-citizens.
So it's only when they don't hold a valid visa that they become an unlawful non-citizen.
But they're on a visa only for the purpose of removing them.
Of removal, that's correct.
That is the only reason they're here. They're on that visa because they need to leave.
Because they have no valid right to remain in Australia.
Right, okay. Thank you. I think that's all the questions I have for you. I'll just double check my papers.
And perhaps it might be helpful to say, of course, the NZYQ cohort are on
BVRs because if they were unlawful, i.e. if they didn't have a bridging visa, we would be required to detain them. And it was the initial High Court decision that said you cannot contain them unless there's a reasonable prospect of removal, which is why they've been given a visa. But it doesn't change the fact that they are on a removal pathway.
Sure. And it's your obligation, Ms Foster, to comply with the law.
That's correct.
Thank you. Senator Patterson or Senator Scarr, did you have any other final questions?
Thank you. Thank you, Chair. So this has been very useful, so thank you to all the witnesses. So I've got my head around Schedule 6 and how Schedule 3 buttresses Schedule 6, to understand that. Ms Foster, when you opened up this discussion, you mentioned three objects for the bill. So I got my head around Object 1, so that's fine. Then you said that the other objective was to deal with a number of impediments in relation to unlawful non-citizens and removing them from the country. And then the third objective was assisting with respect to the BVR cohort and a number of impediments there. What I'm interested in knowing is, and I'm getting my head around the explanatory memorandum, is what those impediments are and how this bill removes those impediments with some sort of particularity so I can just follow. And I understand your comments. As I interpret them, nothing here is intended to change the substantive policy position with respect to the obligation under Section 198 of the Migration Act to remove unlawful non-citizens, where the department has that obligation. That hasn't changed. So I just want to drill down to what are the impediments we're removing and how?
Yeah, thank you, Senator. And I think that important starting framing that we've talked
Sorry, can you just speak up a little?
So important to start, I think, with the framing that we've talked about, in that the bill doesn't change who is liable for removal. And I think, again, a very important point that Ms Sharp just clarified, the bill doesn't allow a third country removal in the sense that we can't do that currently. Section 198 allows that. What the bill does is allows us to enter into an arrangement with a third country. And what that's really about, and I said impediments, another way maybe of thinking about is there are challenges that we face in effecting the removal of a non-citizen from Australia. There's a range of challenges.
So let's deal first with, you're helping me here. Yep. So let's first close out this issue of the third country. So
absolutely,
as I understand it, tell me if I'm wrong, but the position of the department is that's already theoretically permitted under the current legislation. However, this bill will put some more meat on the bones, if you like, in terms of how that happens in practice, including presumably making it clear that there can be some sort of financial accommodation to that third country that's receiving the individual.
Correct. It provides for a framework. I think evidence has already been given that the vast majority of non-citizens who are returned to their home country, but of course there are non-citizens that we are not able to return to their country of nationality. So that's a challenge that we face in removing those people. We can, under law, remove them to a third country, but that of course requires the consent of the third country. This bill would allow us to have a framework to enter into an agreement with a third country that would set up those arrangements and to provide that legislated power, the ability, the spending authority to support the construction of any such arrangement, to then support the removal of a non-citizen to that third country. So in that sense, it's around reducing some of those challenges that we face in discharging our duty to remove non-citizens who don't have a legal right to remain in Australia.
And for whom we cannot return
Correct.
to their own country because of our refoulement obligations.
Understood. Okay, so that's one impediment. Understand that impediment. What's the next one?
We heard quite a bit of evidence earlier about the civil immunity provisions. The kind of core intent behind them is to reflect a principle that once somebody has been removed from Australia, there's no ongoing relationship or obligation that the Australian government has in respect of that person. They had a time in Australia, they were found not to have any visa or ongoing right to be here, and they were removed in accordance with Australian law. And the purpose of the civil immunity provisions is to make that really clear.
So in the absence of that civil immunity provision that's being introduced by the bill, have there been cases where legal actions have been brought in relation to these contexts? There must have been a trigger for the insertion of this civil liability.
I think, and we heard evidence earlier, that the analogy is more to regional processing. So in the context of regional processing, there have been claims in negligence and damages brought in respect of Australia. To my knowledge, I don't think we've had claims in damages brought in relation to the exercise of a removal power before.
Because there's a difference between the government being provisionally liable in the event that it's negligent or fails to discharge its duty with respect to someone who's in a regional processing centre and under the control, if you like, of the Commonwealth Government or its agencies, as opposed to someone who's been removed to a third country and there's no connection.
They're two fundamentally.
Do you understand what I mean?
Yeah, well, they're fundamentally different. I don't know that I'd agree exactly with your characterisation, but yes, we see them as very different relationships insofar as if somebody is removed from Australia, that is the end of their relationship with Australia.
So that's what this civil immunity provision seeking to capture, the latter scenario?
That's right.
That's correct.
So it's not seeking to cover people in whatever the law is, but it's not seeking to extend to regional processing centres. Is that correct?
No, there is a section that does extend to regional processing inserted in after section 198 AD. If you're looking at the bill, it's on page 10.
Oh, I'm actually going through the explanatory.
Oh, right. Sorry. I can. So again, though, that is relating to no civil liability for taking someone to a regional processing country where the action is done in good faith by the Commonwealth officer, and it is also seeking to create an immunity for the Australian government in respect of any action taken by a foreign government in relation to regional processing.
Okay. What does good faith mean in this context?
I think it will be given its ordinary meaning by the court, which
what
is
does good faith mean in this context?
So I think that's a question you could ask any one of us. What does it mean? And that will be something that would be tested in a court. The boundaries of that.
I think
so. There are no examples given of what's not in good faith. So I understand as a general proposition, you've got to interpret good faith in the context.
So I think an officer who is honestly and diligently performing their duties, if they made an error, that they'd completed all of their training, they'd been well trained, they had access to the right equipment, and there was an error made, somebody slipped, for example, and then, that I think would be the sorts of things we would look to demonstrate that they were acting in good faith.
Perhaps by contrast, Senator, if officers
were negligent in following proper process, did not exercise due diligence in the exercise of their function, then that would call into question whether or not they were acting in good faith.
Because typically you could be negligent potentially, but still meet the good faith obligation.
That is correct. I think what Ms Foster is alluding to, we would anticipate with this type of provision, a court will look carefully at the conduct of the officer in deciding whether the immunity extends to the conduct, and we'll look at that wording in good faith quite closely.
So I would have thought you're looking at a degree of recklessness, willful indifference before you would be considered to breach good faith. Is that a reasonable articulation?
I think so.
All right, can we come back to impediments, Mr Burke? So I've got the civil immunity one now. I understand the third country reception arrangement. Are there any other impediments?
I guess in the third country arrangement, so just to be clear, that wraps up the spending authority and also the disclosure of information. So that would be part of an arrangement. Again, as I said, we can remove people to a third country, but that does require their consent, and we may, through those arrangements, need to share information that we hold on the non-citizen. So that just enables that. So they're all kind of wrapped up in that same removal of impediments / reducing challenges kind of heading.
Okay, so I've just working backwards. Schedule 6, understand. Schedule 5, understand. Schedule 4, I understand. Schedule 3, understood. Schedule 2, understood. Is there anything else in Schedule 1 that's trying to address an impediment?
Schedule 1 contains a provision that isn't related to third country removal. It's got a provision in there that's intended to better assist us to manage the onshore, the individuals on bridging visa Rs, particularly who are onshore, by their existing Section 197D that's already in the Migration Act allows a protection finding to be revisited for an unlawful non-citizen. So that power allows, if somebody's in immigration detention as an unlawful non-citizen, and, for example, if their protection finding had been made many years ago and the country information that led to that protection finding has changed with the effluxion of time, Section 197D allows the department to go back and have a look and consider whether that person still is owed protection in respect of their home country. What the amendment does is extend that power to any removal pathway non-citizen. So it's not about third country removal, it's about checking, does this protection finding still hold, or is it possible to find now that in fact the person isn't owed protection in respect of their home country and could be returned home?
On the basis of some sort of change in their home country, presumably.
That's right. So,
okay.
And I should say, if the department makes that kind of a finding that undoes someone's protection finding, they have access to full merits review and full judicial review of that decision.
Okay. So can I ask you, as I understand your answer on what I've read, nothing here prevents someone from making an application that the circumstances in their country have changed adversely since they made an original application that was maybe rejected, but there's been a change in their country of origin such that they can reapply for protection on the basis of some sort of change in their home country?
Nothing in the bill deals with that. Mr. Kiley might like to talk about the various bars for making multiple protection visa.
Yeah. So, if an individual has already applied for a protection visa and been refused, then they are barred from applying again. And so in these situations, there are sort of two avenues that exist. The first is that an individual can seek ministerial intervention on the basis of changed country circumstances, which would meet the guidelines for the minister's consideration to have that bar lifted to enable the individual to apply again. Separate to that, there are processes the department has in place before any individual is removed to ensure that we're looking at those refoulement obligation issues, and we would consider that as part of ensuring that in any removal process we would not be breaching our international obligations, notwithstanding the fact that someone may have been refused a protection visa many years ago. If circumstances had changed, that would come up as part of that process before removal.
And so just to reiterate, Senator, those are existing provisions within our existing regime. The difference that this bill introduces is it allows us to revisit a protection finding for someone who is on
a removal pathway.
Our evening's end, and I'll need to hand the call back to Senator Shoebridge in a moment. So if you have
one last question.
Yeah.
So what would so the last question? What would trigger that reassessment by the department? How would that be triggered? Is that almost self-referring, that you're monitoring the position in different countries, or?
Well, essentially, we will work closely with Mr. Thomas and Ms. Jeffrey's teams who are responsible for individuals who are on a removal pathway. If there are individuals in that pathway that have a protection finding, then that's a barrier to removal. So we'd engage with their team about whether Section 197D may apply. So if these amendments are passed, that would apply to that cohort of individuals that Ms. Sharp mentioned. We would then sort of undertake an initial assessment based on the information we have to hand about their original protection finding, any other information that's come to light about their circumstances in the meantime, any changes in country information. If we consider through that assessment that the protection finding would still be made, then effectively no finding would be made under 197D, and they would continue to not be able to be removed to their home country. If we consider it is possible that a different decision could be made, then we will go through a full assessment process. Procedural fairness would be afforded to the individual as a result during that process. And as Ms. Sharp mentioned, if we were to change the decision and make a determination under 197D that the protection finding is now no longer able to be made, that will be subject to merits and judicial review.
And so essentially, Senator, it's another limb of assisting us to meet our duty to remove by ensuring that we're not constrained in our removal options by something which is no longer valid.
Okay, thank you. Thank you, Chair.
Senator Scarr. Senator Shoebridge, we're coming back to you for 7 minutes.
Thanks, Chair. I'm keen on the 9:30 hard deadline as well, to be honest.
It's been a long day.
Secretary, I was listening closely to your answers to Senator Scarr about the classes of people who would be subject to removal to a third country as identified in Schedule 5. And your answers included, and I think I took it down word for word, people who you can't return to their own country because of our refoulement obligations. Do you remember saying that?
Senator, it's a little bit out of context for me, but keep going.
Well, do you remember saying that one of the categories of people who could be subject to removal to one of these third countries were, and I took note of what you said, people who you can't return to their own country because of our refoulement obligations. Is that true?
Senator, that statement is true.
Right. What are our refoulement obligations?
Australia's, and I think Ms. Foster's statement is true, although I think she probably was more generally referring to our non-refoulement obligations, but they're set out in the Refugees Convention, the Convention Against Torture, and parts of the ICCPR. I probably don't need to spell that out for you, Senator.
And to be utterly clear, there is no limitation at all under this bill about entering into an arrangement with a country that doesn't have those refoulement obligations. I think we had that discussion earlier.
Australia is a signatory to those three conventions, and its obligations under those conventions are things that would be complied with in the exercise of its...
But you've repeatedly said, in multiple answers to my colleagues, that once somebody has removed from Australia to one of these third countries, that's the end of Australia's legal obligations. Correct?
Correct.
You've repeatedly said that. And if those countries don't have their own legal constraints on refoulement, then under your rationale, no problem for Australia, because our legal obligations end when they leave our shores and enter that country.
Senator, I think
that's
Senator, I think your
necessary conclusion from this.
I don't believe that's right, Senator, because it assumes that we would have an agreement with a country that did not have those obligations. I think what we're trying to say is very clearly the bill sets out a mechanism for us to make arrangements with third countries and Australia will continue to meet its refoulement obligations.
Well,
Those
if you
two
wanted
things
to
go
limit
side by
it to
side.
countries that were parties to the Refugee Convention, if that's the intent, why isn't it in the legislation?
That was not my answer, Senator. I said the basis of what you're putting to us assumes that we would do that, and that's not an assumption that I think
I'm just saying you can, and you clearly can. And for some reason, there's no restriction on doing it. And I'm wondering why there is no restriction on sending it to third countries which don't have those same refoulement obligations.
Senator, there's a range of things I think any government would take into account as it's thinking about whether to enter into a third country arrangement.
The cheapest one.
Pardon?
The cheapest one. You know.
And one of those
926, you don't need
considerations
to
will be
interrupt
Australia's capacity to meet its obligations under its international obligations.
And I think, and Ms Jeffrey might be able to provide more evidence about this, but whenever we effect a removal, we do seek assurances from the country that we're removing somebody to, that they will, they won't chain refoul.
No legal obligation to do so under this bill, though. Do we agree on that?
Yeah, the legislation does not set out.
But Senator, you can't look at the bill in isolation. Alongside the bill are Australia's obligations to meet its international obligations.
Well, I invite you on notice to identify any actual domestic legal restriction that would prevent the government from doing so. And I've just given the time, I'd ask you to provide that on notice. To go quickly to the liability, the immunity provisions, 198 AD 11, 11B, that has a series of matters in which it seeks to remove civil liability. So 11B says no civil liability is incurred by an officer of the Commonwealth, including the Minister or the Commonwealth, in relation to any act or thing done or omitted to be done. And then you've got a variety of different elements, and they're all or. So they're all separate, is that right? A is separate to B, is separate to C, is separate to D, and is separate to E? Correct?
Yeah, they've all got or written between them.
And A has a good faith limitation on it, doesn't it?
Yes.
But B and C and D and E and F and G, none of them are subject to good faith, are they?
Well, I think B and C, which are talking about the actor in the, it's a person doing a thing, do not have a good faith requirement attached.
D, E, F, G, none of them have good faith? There's about sending people off to a regional processing centre. None of them have good faith.
Yeah, but I guess I would clarify that D, E, F and G are about the circumstances in which the act is done, whereas A, B and C are talking about the entity doing the act. Anyway.
So a Commonwealth officer may well know that a regional processing country or another foreign country has a lack of protections, or does that impact on the reason why there's no good faith limitation? Because you probably know that regional processing countries, other foreign countries, may well be acting without good faith. And you want protection. Because that's what's happened in the past. That's what a bunch of claims have been about. Third countries acting brutally without good faith.
If you want to answer suggest you wait for it.
I think that the reason B and C don't attempt to put a good faith limitation on a foreign government is simply that is very hard for us to have any, that it's a foreign country. We can't legislate to bind.
And those provisions, Senator, sit alongside Australia's obligations to meet its international obligations in the original decision it makes.
In relation to which you've taken on notice what, if any, domestic actual legal constraints there are.
Thanks, Senator Shoebridge, and thank you for your time and evidence and for the work that you do. That concludes today's proceedings. The committee has agreed that, we need to seek to agree to that questions to answers taken on notice at this hearing should be returned by close of business by 9 a.m. Monday the 25th of November 2024. Obviously, if we can get if there's any routine question answers and we can get them sooner than that, that would be very helpful, but we note the short-term time frame.
We'll do our best, Senator, understand how tight the time frame is for the committee to consider.
There wasn't too many that were. I thank all witnesses who've given evidence to the committee today. Thanks also to Broadcasting and the Secretariat. I declare the hearing adjourned. Thank you.
Thank you. Very helpful.